Dear ladies and gentlemen, I would like to welcome you at our international conference, the official language of which is English, so obviously over time we will change to English. However, first of all, I would like to request László Komáromi, Dean of the Pázmány Péter Catholic University, to please hold his opening speech.
Honorable Chief Justice Attila Horváth, Honorable Justice Zhang Zhangmi, Honorable members of the Constitutional Court, dear Deputy Commissioner, ladies and gentlemen, I warmly welcome you at the Faculty of Law and Political Sciences of Pázmány Péter Catholic University. A few years ago, my siblings and I inherited some agricultural land from our grandmother in southern Hungary. We ran a small family farm on it. Over the past 3 years, we have seen that recurring severe droughts repeatedly threaten our crops. The corn is poor, the sunflowers are close to drying out. Without agricultural support from the European Union, our business would be unprofitable. It has been almost 30 years since I began my law studies at this law faculty. Environmental law, global ecological subsystems and their functioning were already a compulsory part of the curriculum at that time. We studied a 1972 report entitled The Limits to Growth. I remember one of our lecturers, Professor Péter, saying even then that climate change would mean that wheat will no longer grow in the Hungarian Great Plain, only sorghum. Well, wheat is still growing, but other, more demanding crops are becoming increasingly scarce. Another of our teachers, János Pál, used the analogy that the serious damage to the Earth's ecosystem is like a tanker that has just spotted an iceberg in the ocean, right in its path. The question is whether there is still time to avoid it. The inertia of the economic and political system built by humankind is enormous. The question is whether the collision can still be avoided. More recently, he used the analogy of the airplane. The question is whether a soft landing is still possible, or whether only a hard landing is possible in which we will suffer serious damage. Whether corn, wheat, and sunflowers will grow on our small family farm is not really a pressing issue for us because we do not make our living from farming. For my siblings and me, it is a secondary activity. But what will happen to those who live from it? And what will happen to those whom climate change will force not only to give up their livelihoods, but also to leave their homes and seek survival as refugees? This conference seeks answers to the question of what the legal profession, lawmaking, and in particular the application of law and the various courts can do to ensure that our landing is a soft one. What tools do we lawyers have at our disposal to seize the last chance to protect our climate and preserve the Earth's ecosystem in a way that it is bearable for us? The Catholic
megőrzésére. A Katolikus Egyetem küldetésénél
to study the serious contemporary problems of the world and humanity and to seek solutions to them. It would be difficult to name a more important contemporary problem today than climate change. We feel its effects on our own skin, and we know that our children's future is at stake. Thank you for coming from almost every corner of the globe to share your knowledge and experience. I would also like to thank the conference organizers and the main organizer, Professor Marcel Szabó, for making this exchange of ideas possible. I sincerely hope that the knowledge and experience shared here will contribute to the preservation of our common home, the Earth. Thank you for your attention.
The Chief Justice of the Hungarian Constitutional Court, Professor Attila Horváth, to open this conference on behalf of the Constitutional Court.
Dear Dean, dear Constitutional Court, dear professors, dear colleagues, the climate protection is obviously one of the most important tasks for us. Unfortunately, when we look around in the country, in other fields as well, and in Europe, most part of mankind lives in cities and they don't perceive the real weight of this problem. We could say that climate protection means for them they install an AC unit in their flats, and that's how they protect themselves against overall climate warming. But we do our best to counteract these bad processes and to preserve our Earth, the Carpathian Basin, for the next generations. The Hungarian Constitutional Court feels in this to do everything in its power, and the Constitution says that natural resources are the assets of our national community, and the preservation of it for future generation is always the task of the state. And we also highlight that in the Carpathian Basin, the natural endowments and natural assets shall be preserved. And Article number 20 of the Constitution connects the protection of nature with the protection of the health. And it also says that everybody has a right to a healthy environment. The Constitutional Court is also committed, because we made a lot of decisions. Yesterday we received the latest one in this row, which focuses on climate protection and nature conservation. And Marcel Szabó is spearheading these efforts because he's also committed. And he's, in most cases, drawing up these legal texts, backed up with the right arguments. So within our assets and within our possibilities, we try to protect our natural environment. Of course, everybody has his task and her task to take measures in their respective fields, because we are in our number 24. There's a huge warning now ahead and right now, because we always kept seeing that in the far future these problems are going to emerge. But the Paride salt mine tragedy perplexed probably many people, and made us aware how important it is to protect nature. So I wish you a good work and nice and good presentations. And tomorrow I will also hold a presentation about the Constitutional Court and about the role of the historical constitution in terms of climate protection. Thank you very much for your attention.
Two young persons is going to take the floor. They have turned to the Constitutional Court in association with the proceedings related to the climate change. They were claiming their voices, they were claiming their rights to be heard, and now I would like to ask them, Földesem a Flóra and Kapitány András, to come here and tell their statements to this conference as well.
Köszöntök mindenkit.
So welcome everybody. My name is András Kapitány. I'm 14 years old. Climate change has palpable consequences. I would like to highlight two of them. The first is when I attended kindergarten, we could go sledding every winter. This is not so easy anymore because we had winters where we hardly had any snow. And New Year's Eve, we had 12 centigrades. And the other thing is, even in my life, climate became unpredictable. When we think of May this year, 2 weeks ago we had to wear a jacket, and now we have more than 30 centigrades. Why it is necessary for us to protect the climate? In order to create living circumstances for us which are livable, and it is important to act against the climate change, because if we do something today, it will have a result when we grow up. And even if, yet if we have to do that when we grow up, it will be maybe late. Climate protection is important for all of us. On one hand, for us young people, it means the future to have a livable world, and we don't have to live with 45 centigrades in the summer. Drought is jeopardizing also the production of foodstuffs. Everybody can do for climate protection. For example, when we insulate houses, when we modernize the heating systems, and when we use LED light bulbs. With these steps, we not only serve the climate protection, but we can also save some money. And because of this, it is essential that decision makers also think that climate protection is important, and they back up the reduction of climate change by bills. And because of this, I also joined the bill of MTTS, urging the revision of the Climate Protection Act. And yesterday we were happy to see that the Climate Constitutional Court followed suit with our request, and we hope that the Climate Protection Act will be established, which acts now without leaving the solution of the problems to our generation. Thank you.
I'm asking Laura to come and join us and tell her statement.
Tisztelt Hölgyeim és Uraim!
Dear ladies and gentlemen, today we have gathered because of an extremely important issue. Climate protection affects the whole Earth. It has a huge impact on the planet and on the basis of our lives. Climate change and related problems shall be resolved without any delay. You and me were born inside of the consumer society, and the resources of Earth are depleting and being consumed. Our consumption became distorted. It is not only serving our well-being. It is clear that we have to change, and change is always difficult. And my generation will be impacted in an unproportional way to keep up the development of the economy and to ensure a livable environment. I will start working 2033. What kind of hopes can I have without the change of the Climate Act? Among my friends, I see that they are concerned about the future. We know that huge changes are going to take place still in our lives, but we don't know what it will be like. I remember my grandmother. She lived in a small village, and they prepared food for themselves. They played together. They were singing together. They had a lot of arable land and a lot of animals. They were living in harmony with nature. In later decades, we take much more and we consume much more than what would be needed. And the way we live is not sustainable. I know future is not be like past, yet I wish that the same harmony told to me about by my grandmother comes back. And I have signed the letter of the MVVS young youth department, because life in future is at stake. I see the solidarity with poorer countries. We have to back up each other. We have to collaborate in order to have results. And on the other hand, everybody should be involved in the solution. We can act individually as also on team level. We can act as students, core, and judges. And I'm very happy about the judgment of the Constitutional Court. I feel that we are much closer to reaching our goal, and I initiate that the Parliament implements the tasks set by the Climate Protection Act. We children cannot decide on the previous development of the world. Yet we ask you adults to help build a future where we can live in a healthy environment. We all are responsible for future. Thank you for your attention.
On behalf of the Constitutional Court, I would like to say thank you for these words of András and Flora, and for all the other children who have been joining the written amicus curiae handed in by the Magyar Természetvédők Szövetsége, Association of, what is your official name? National Association of Nature Conservation. Thank you very much. And at this moment, I would like to introduce President Luc Lauritzen, our next speaker of the morning. President Luc Lauritzen is Professor Emeritus at Ghent University and also former director of the Center for Environment of Energy Law of the university. He is the president of the Constitutional Court of Belgium from 2020, and he is the most shy and modest person in his personal capacity whom I have ever known. A few years ago, a law lord came over for Cambridge, and the students asked, "Is he a real law lord?" Because he was taking EasyJet. He must have been wrong. And when your arrival was discussed at the Constitutional Court, it turned out that you would have been entitled to several police cars with blue lights coming through the city, pushing away everybody else from the roads. I'm sure that is not your mentality and it is not your approach to life. And no wonder, as President and Professor, Luc Lauritzen is not only president of the Belgian Constitutional Court, which is a wonderful and most prestigious position, but also he has undertaken the service to act as the president of the European Forum for Judges. And he is going to introduce the wonderful judgment of the Belgian Constitutional Court for us. Please, President Lauritzen, take the floor.
Sure, of course. Of course. Of course. But if you prefer, take a seat here.
So, good morning. Thank you very much for this invitation, dear colleagues, and especially my colleagues from the Constitutional Court of Hungary. So I will speak about climate change litigation not only before the Belgian Constitutional Court, but also before the civil courts in Belgium. So I should start maybe with some words of explanation about our courts and what we do and can do. So this is our building. So what are our competences? The Constitutional Court reviews acts of Parliament, of the federal and the regional parliaments. And we check their conformity with the Constitution, but also with international and European law. There are two ways to enter the court. The first is by way of direct action, so every federal act, regional act can be challenged within a period of 6 months through a demand for annulment, and secondly, through preliminary rulings. So if an ordinary judge is confronted with a question of constitutionality of a law, he has to refer, or she, more and more she, has to refer the case to the Constitutional Court. So we don't have concrete cases, the appeals, constitutional appeals against judgment, so our intervention is more preventive. So we don't have the Verfassungsbeschwerde or the amparo. And this is the difference with Germany, with South Korea, and now with Hungary. In Belgium, we don't have a comprehensive federal act or on climate change. We have specific acts. This means that we don't have case law at the Constitutional Court over the overall ambitions of Belgium in terms of mitigations, because you can only challenge acts which exist, and this do not exist, and that's why I will speak in my second part about the civil courts which have a different competence. So our case law in climate started in 2006, so at that moment an act of a regional parliament which transposed the European emission trading scheme, the first version of was challenged by a steel company, Cockerill-Sambre Arcelor, and you have to know this was the first commitment period of emission trading. This will you have the national cap, the national allocation, and then the allowance were given for free for a certain period of time. And in the first period, only the major emitters of carbon or greenhouse gases were in the system. So the steel industry was in the system, but for example, not the non-ferro. And so the company was complaining about discrimination. Why should we be under that system, and why our colleagues from the non-ferro would not? And the court said, okay, we are in the first period. It's justified that the legislators start to tackle first the largest emitters. Secondly, the court said climate change policies justifies limitations on the freedom of enterprise and also on property rights, because one of the features of the law was that if you stop your activity, because the allowance were in principle given for 3 years, but if you stop your business after 2 years, you lose the allowance for the last year. And the company was complaining, saying, but that's our property, and you're taking our property away without compensation. The court said, no, that is justified in the light of climate policy. And the court found also no discrimination compared with other sectors. It's a good thing to start first with the largest emitters and in the future you can go after other sectors. And there was also no violation of freedom of establishment. So this was a transposition of a European directive. The court took in 2006 this vision. Happily, 2 years later, the Court of Justice of the European Union said exactly the same, but on reference of a case by the French Council of State. Another, this is a typical Belgian thing, it was the extension of the emission trading scheme to aviation. And in Belgium, climate policy is mainly a regional issue, and here the question was which of the regions can regulate air companies which are based in Belgium. The two regions thought, the Flemish region and the Walloon region each have an airport. They say the planes of the companies who are using most intensely our airports, that's our competence. And of course they liked, because meanwhile we had auctioning of the allowances. They liked the proceeds of this auctioning. The court said no, this problem is not limited, the emissions of aviations are not limited to the surroundings of the airport. It's a global problem. It's also about aviation in general. That's a federal competence. You cannot do this. You have to regulate it with what we call in Belgium a cooperation agreement, sort of internal treaty between the federal and the regional levels to specify who will do what. And the court said you have some time, annulled the legislation, you have some time to come with such an agreement. And finally that has been done, except for one problem where there's still no agreement between the region and the federal government. That's the proceeds of the allowances of aviation. We have various judgments concerning green certificates, so instruments which an instrument that try to incite the uptake production and uptake of green electricity. And also there the court say in general these systems are justified. There is a need to reduce greenhouse gas emissions. The support for the development of renewable energy fits in that purpose, and there is a wide margin of appreciation of the legislators, because there were some companies were complaining we have a technology that should have more let's say support than we get, etc. Court say this is a very technical issue, and also market conditions are changing rapidly. One must also to avoid over-subsidiation, etc. And the court said there is, in fact, some room for the legislature for trial and error because the legislator has to invent new legislation in a new field, starting with the market conditions the moment the legislation is taken, but they are changing rapidly. So we should have some reservation towards you cannot ask too much of the legislator because things are changing, but the principle of legal certainty must be respected, so you cannot change the conditions overnight without announcing it in time. Interesting here, there was also a complaint about the fixed administrative fines per if you electricity distribution companies must buy sufficient electricity and acquire the green certificates if you are as a company, you don't buy sufficient green electricity, there is a fine per missing permit. And the court said this is not only a sanction, but is also an economic incentive, and that's why that fixed sanctions per missing certificate is in this case justified. So normally for sanctions you have the proportionality test, intention, etc. Because in this economic issue that is not playing a role, these fixed tariffs are okay. Other judgment about the obligation to blind fossil fuels, I will not go. Maybe one thing, someone was complaining that this obligation was violating the freedom of religion because the person in question believed that you may not grow crops. You can grow crops for feeding people, but it was against her religion that those crops would be used to produce energy. Another question about the reduction of parking places in the Brussels capital regions, also there the court found this is justified by the objectives of climate change. And the last one, a judgment on the phasing out of fossil oil-based heating of houses. There was a complaint saying, first, this is violating my property rights because now I cannot heat my house anymore in a certain day. I have to change towards natural gas. Court said this is justified by the objectives the government must deliver. And another complaint was also now there is a permission to still use natural gases. Why is that? And the court said, of course, natural gas is also creating greenhouse gases, but to a lesser extent, this is justified. So, summarized, nearly all the cases we got to the Constitutional Court were brought by industry, which are unhappy with climate change obligations or seeking more support for their type of renewable energy production. But the court says constantly climate change policies and overriding public interest that justifies restrictions of various rights and liberties. Also, difference in treatment between sectors, etc., can relatively easily be justified, especially in the early stages of policy development, where the legislator has to work with limited information, limited experience, and so on. We have also Article 23, that's the right to a healthy environment, and Article 7 bis of the Constitution, that is sustainable development. But till now, this is not much used in these cases by the complaints we get. Furthermore, emerging climate change law can be construed, I think, in a manner that is compatible with fundamental principles of the rule of law. But the Constitutional Court is what they call a negative legislator. We can only sanction what's brought to us and what we think is unconstitutional. So the room for positive lawmaking is limited, and we don't have at our disposal, we can only sanction, annul, suspend the types of remedies you can find in the Urgenda case. I come now to what's called the Belgian climate case, and this is in Dutch the Klimaatzaak, and that's a human rights-based civil lawsuit which were brought to the civil courts. Why? Because we don't have a comprehensive climate law in Belgium. The Klimaatzaak is an NGO, in fact, small NGO, but the case is supported for the moment by nearly 60,000 individuals. They are arguing that Belgian law, civil law, in combination also with human rights law, requires the Belgian government to an approach to reducing greenhouse gas emissions that should be more aggressive than what they are doing now. The suit is against four authorities. Why? Because climate change policy is a mixed competence. Some competences are on the federal level, some are on the regional level, and their initial claim was to reduce the overall emissions from Belgium with 40% towards 2020, 87.5% towards 2050. First judgment, it took some time, because one of the first things one had to settle in Belgium was in which language the case could be judged. I will not go in that. So in 2021 there was a first judgment of the Court of First Instance in Brussels with, I would say, mixed outcome. First, the standing both of the NGOs as individual plaintiffs was accepted. One exception, there was also a claim by trees represented by some people, but the standing of the trees was not accepted. Furthermore, the court said the global dimension of climate change does not impede the application of Articles 2 and 8 of the European Convention of Human Rights. And so this is the same as in the Netherlands. There is a huge parallel between these cases. And the court came to the conclusion that Belgium was not in compliance with international and European Union climate commitments, but, and here was the weak point, there was no injunction to say you have to do more than what you are doing, and the court argued that would be breaching the separation of powers. So the case was appealed before the Court of Appeal in Brussels, and in November 2023, just one day before the opening of COP28 in Dubai, at that moment there was a different outcome. So the Court of Appeal confirmed the finding of breaches established in first instance, except now one region, the Walloon region, because meanwhile the Walloon region had adopted a regional climate law with more ambitious climate objectives. But in addition to finding a violation, the court orders the condemned authorities to reduce their greenhouse gas emissions. And the Court of Appeal considers that using its power of injunction against public authorities does not necessarily infringe the principle of separation of powers, provided that judges does not take the place of the authority in choosing which concrete means one should use to, let's say, come up with the objectives. You see, here the judgment is nearly the same as the judgment of the Supreme Court of the Netherlands in the Urgenda case. Secondly, the competent Belgian public authorities, now the four together, have been ordered to reduce their greenhouse gas emissions with 55% compared with the 1990 level by 2030. This is going further than the European Union obligations. Under the European Union obligations for what they call the non-ETS sectors, Belgium has to reduce its emissions with 47%. With the ETS together, one will be around 50%. This, in fact, is an additional 5% reduction which has been imposed. And the injunction is based on the breach of human rights, Article 2 and 8 of the European Convention of Human Rights, in combination with civil liability rules, the duty of care of the government. There was also, the parties also asked for the penalty payments if one is not delivering on time. The Court of Appeal suspended its ruling on the question, but the case is still pending before the court because at the request of one of the parties, after reporting on the results obtained so far, the case can be taken again into consideration, and there is an obligation for the parties to report after every period about the emissions, the real emissions according to the inventories of the emissions. So the judgment has been both criticized, mainly also by some of the governments, I come back to them, but praised by others. So standing for nearly 60,000 complainants was accepted, and also moral injuries have been accepted for standing. For example, the risk for food shortages, heat waves, rainstorms, avalanches, and also eco-anxiety, so people who really feel themselves not comfortable with the situation has been accepted as a sufficient reason to have standing. There is also an important discussion on the protection of future generations, which is, I think, very important. And human rights have been used as a benchmark. Also, the drop in the ocean, that's the classical argument. Look, Belgium, it's less than 1%, maybe less than 0.5% of the global emissions. Of course, one forgets the historical emissions, for example. Argument saying, but look now to China. So this argument has not been accepted by the court. So the court says everyone has to do its part to come to a global solution. And I think that meanwhile the judgment of the European Court of Human Rights in Klima Signorine is comforting this position because it goes in the same directive. Also, navigating climate liability of competent authorities in a complex federal state with shared competences in respect both of climate mitigation and adaptation is a tricky issue. So the Walloon region has been accepted from the constatation of a violation, but must work together in the future and together they have to come with a plan to reduce the emission as imposed. But the case is not final because one of the 4 regions, governments appealed the case, the Flemish region, saying our European Union obligations are already too much, and now this extra 5%, let's say, is impossible for us. So the case is now pending before the Supreme Court, so the Court of Cassation, and we expect a judgment in the coming months to see if that judgment of the Court of Appeal is confirmed or not. So let's wait and see. I would say thank you for your attention.
Thank you very much, Lukla Vissan. It was a very inspiring and interesting presentation. Now we are looking for another country, for another example of excellent climate protection activities on behalf of the judicial branch of the state. And I would like to introduce to this wonderful audience Justice Zhang Zhangmi, who has been Justice of the Constitutional Court of Korea since 2023. She served as a judge for more than 20 years before being nominated and appointed to the Constitutional Court of Korea. In 2014, when the Constitutional Court of Korea adopted its climate decision, Justice Zhang was also in the panel and, most importantly, very much supported the decision in which the court found that the Korean Carbon Neutrality Act's emission target for 2020 should be declared unconstitutional. Justice Zhang Zhangmi, the floor is yours.
Sorry, I don't have like this, so you just listen to me. I'm happy to be here. Honorable Justices, distinguished guests, good morning. I am Jung Jung-mi, Justice of Constitutional Court of Korea. Last August, the Constitutional Court of Korea issued a landmark decision declaring that a statutory provision did not conform to the Constitution due to its failure to specify mid- and long-term carbon reduction targets. I'm honored to present this case today, and I would like to thank Justice Marcel for the kind invitation. In my remarks today, I will explain the background of the case, the subject matter of review, the core legal reasoning of the court, and the broader significance of the decision. The case before the court was a constitutional complaint challenging whether the greenhouse gas reduction targets established by law and administrative plan were sufficient to meet the state's constitutional obligation to respond to the climate crisis. The Constitutional Court consolidated 4 related complaints, had 2 public hearings in April and May of 2024, and proceeded to review the merits. The complainants included 19 teenagers affiliated with a youth environmental group, along with 62 children, one of whom was still an unborn fetus at the time of filing. Altogether, the case involved 254 complainants. These complainants were filed between 2020 and 2023, a period during which Korea was already acutely aware of the accelerating climate crisis. In 2019, Korea recorded the warmest winter in its history. During the preceding decade, the frequency of extreme weather events, heat waves, cold spells, and droughts increased. Since 2011, the Korean government has published annual reports on extreme weather. The report published this year stated that 2024 was the hottest year since 1973, with the average national temperature 2 degrees Celsius higher than the 30-year average. That summer, the heat wave extended into September, and the country experienced an average of 20 tropical nights, 3 times higher than the historic average of 6.5 nights. In Seoul, tropical nights lasted for 34 consecutive days. The sea surface temperature last summer was also 2 degrees Celsius higher than the previous decade's average. In short, in 2024, Koreans experienced the reality of the climate crisis firsthand. It was in this context that the Constitutional Court delivered its decision on August 29. The court reviewed 3 main instruments. First, the Framework Act on Carbon Neutrality and Green Growth for Coping with Climate Crisis, enacted in 2021. Second, its enforcement decree enacted in 2022. And third, the first national plan for carbon neutrality and green growth established by the government in 2023 under the Framework Act. The court found that Article 8, Section 1 of the Framework Act did not conform to the Constitution and ordered the legislature to amend it by February 28, 2026, while the provision remains in effect until it is amended or until the due date, whichever is sooner. The court rejected the complaints regarding the enforcement decree of the Framework Act and the part concerning sectoral and annual reduction targets within the national plan. All other complaints were dismissed. I will now turn to the laws and principles applied in this case. Article 35, Section 1 of the Constitution of Korea guarantees the environmental right as an independent fundamental right. It states all citizens shall have the right to live in a healthy and pleasant environment. The state and the citizens shall endeavor to conserve the environment. Additionally, the preamble of the Constitution expresses a commitment to ensuring the security, liberty, and happiness of future generations. The court held that the state's duty to conserve the environment includes a duty to mitigate and adapt to climate change, and that the adequacy of this duty should be evaluated under the principle of prohibition of insufficient protection. This principle required the state to take measures that possess the minimum necessary characteristics to correspond appropriately to the foreseeable risks posed to fundamental rights, in this case, the risk of climate change. To assess whether the state had met this standard, the court examined 2 factors in light of scientific facts and international standards. First, whether the reduction target reflected Korea's fair share of the global effort to reduce emissions. And second, whether the institutional framework guaranteed effective emissions reductions without shifting undue burdens to future generations. The court also considered the principle of statutory reservation, which requires that key matters involving fundamental rights must be prescribed by legislation, not left to administrative discretion alone. The court held that the degree to which reduction targets should be specified in statute can be reviewed under that principle. Next is the application of these laws and principles and the court's reasoning. The article at issue, Article 8, Section 1, defined Korea's mid- and long-term reduction target as reducing emissions by a ratio prescribed by presidential decree, no less than 35% from 2018 levels by 2030. The enforcement decree later set this ratio at 40%. The court found that, taken together, the statutory provision and the presidential decree prescribing the 2030 target did not fall below the minimum threshold required by the Constitution. The court acknowledged that determining such targets involves complex scientific analysis, technological feasibility, and policy considerations, including economic and diplomatic factors. In light of this, it concluded that delegating the specific figure to presidential decree was not in itself unconstitutional. However, the court identified a constitutional flaw not in what the statute said, but in what it left unsaid. Article 8, Section 1 of the Framework Act failed to set any greenhouse gas reduction targets for the years between 2031 and 2049, even though the law mandates that Korea must reach carbon neutrality by 2050. This legislative omission meant that there was no institutional framework to ensure a steady and continuous reduction of emissions toward that goal, and as a result, shifted excessive burden to the future. The government argued that the current statute mandates periodic review of reduction targets every 5 years, and, if needed, revision in accordance with the principle of progression. However, the court found this framework to be inadequate. Without clearly defined mid- and long-term targets, climate policy risks becoming overly dependent on changing circumstances and administrative discretion, making it difficult to maintain consistency and ensure accountability. The government pointed to challenges, such as Korea's manufacturing-centered economy, its relatively late emission peak compared to other advanced countries, and the importance of energy security. But the court held that these only highlight the need for clearer legislative direction. For these reasons, the court held that the statutory provision violated the principle of prohibition of insufficient protection by lacking the minimum necessary characteristic as a protective measure against climate crisis. In addition to finding the violation of the principle of prohibition of insufficient protection, the court held that not prescribing any basic quantitative level of reduction targets from 2031 to 2049 also violated the principle of statutory reservation. The court explained that the basic content regarding reduction targets and reduction pathways from 2031 onward should be directly prescribed by statute, given that setting reduction targets requires a high level of social consensus. It also found that the legislator has concrete duty and responsibility of legislation with regard to mid- and long-term greenhouse gas reduction plan, considering that future generations have little or no voice in today's political processes, even when they are most exposed to the effects of the climate crisis. In short, the court concluded that the lack of any quantitative reduction targets for the years between 2031 and 2049 violated both the principle of prohibition of insufficient protection and the principle of statutory reservation. Accordingly, it held that Article 8, Section 1 of the Framework Act infringed the complainant's constitutional right to a healthy environment. Allow me to briefly reflect on the broader significance of this decision. First, the court affirmed that the fundamental right at the heart of climate governance is the environmental right. Second, in applying the principle of prohibition of insufficient protection, the court considered whether the measures adopted by the states possessed the minimum characteristics necessary to address the climate crisis. In making this determination, the court took into account scientific facts and international standards to assess whether the measures appropriately corresponded to the nature and severity of the risk posed by climate change. Third, the court affirmed that the Constitution imposes duties on the state to preserve the environment not only for current citizens but also for future generations. Lastly, I believe this decision has made a meaningful contribution to the protection of the environmental rights and to the security and well-being of future generations. When the legislator amends the Framework Act by the due date and prescribes reduction targets from 2031 to 2049, the environmental rights of the Korean people and of future generations will be further strengthened. This ends my presentation. Thank you.
And dear ladies and gentlemen, now we are moving back to Hungary, not only physically but spiritually as well. I would like to introduce Sándor Szemesi, who is Chief Advisor at the Constitutional Court, working with myself. His areas of expertise include environmental law, the rights of persons with disabilities, and children's rights, European law, international law, and many other fields. In addition to his work at the Constitutional Court, he is visiting lecturer at the Pázmány Péter Catholic University, an advisor to the Minority Rights Institute in Budapest, and managing editor of the Hungarian Yearbook of International Law and European Law. Ladies and gentlemen, as you know, probably, the Hungarian Constitutional Court has adopted its climate protection decision. It's, I think, a milestone decision in the history of the court. And on this occasion, I would like to greet especially Erzsébet Schmuck, who was the person who held the whole petition on behalf of the parliamentary representatives in her hands, and was behind the application process. So thank you very much for coming. I hope you are not entirely disappointed with the judgment. Thank you. And we will touch key points how the Constitutional Court was dealing with climate matters today and tomorrow. And we divided, after careful consideration, between Sándor and myself to speak about it. So it's not going to be a repetition that tomorrow we will somehow from another angle touch this topic. I asked Sándor to hold his presentation, and I specifically asked him to hold it in Hungarian, as the majority of the audience is Hungarian, and I think you didn't have the possibility to hear the main essence of the judgment so far. So Sándor, please take the floor.
szépen!
Everyone, dear Justices Jangmi, Justice Marosi, Justice Varga, Justice Szabó, Justice Sanda, if I'm right, Deputy Commissioner Bandi, and other members of the audience. Thank you so much for the possibility for being here. And when we started to organize this conference, we had at least 3 different plans. Plan A, Plan B, and Plan B. The Plan A was the best case scenario when the Hungarian Constitutional Court adopts a decision before the starting of the conference. The Plan C was the worst case scenario if the case is still pending now and we are not in position to speak about any element of the case. Fortunately, we have the possibility to speak about the decision. My presentation will be held in Hungarian because of 2 reasons. This is a brand new decision, and I'm nearly sure that most of you have heard about the decision, but I'm quite sure that none of you know the decision in detail. And this is why I try to introduce the background, our considerations in Hungarian. And I try to focus elements which are important for the Hungarian audience. Tomorrow, Justice Szabó, who was the rapporting judge of this decision, will introduce the decision in the international legal sphere, focusing on the international law aspects and relevance of the case. This last night, I tried to provide a short English extract and summary about the decision. And if you check this QR code, you can download this short English version. This is not an official translation. This is a translation provided by myself last night. So sorry for all the mistakes and errors, grammatical errors in this text. I hope that during the next week, or maybe then the week after the next week, we can provide you an official English translation. So I will continue in Hungarian, and sorry for the inconvenience for our foreign guests.
The Hungarian Constitutional Court, when this decision was made and when we had to deal with this issue, then we found ourselves in a specific situation. We searched, before making the decision, we searched on many occasions in international databases as to what climate-related decisions were adopted. In some of the databases mentioned some local level court decisions with less effect, while Hungarian law would be perhaps appropriate for making cases like that. I'm making some advertisement for Csaba Kis, director, who's dealing with this kind of issues, and to question if there's a possibility to initiate cases like what the Belgian gentleman mentioned. And Hungarian law is very stable in this respect. In the legal framework of most countries, there's one basic right in connection to climate change, and it's the right to healthy environment. In the Hungarian legal framework, we can find 3 or 4 titles, legal titles like that. Obviously, the right to healthy environment is also found in Hungarian law, but there's one more additional item, the protection of natural resources. And there's an item which requires the consideration for current and future generations. And there's another expert, Professor Bandi, who is tasked with the idea of taking into account future generations and climate issues. And the preservation of natural sources are mentioned in one of the articles. However, in Article P, there was another consideration we had to examine if climate is under the Article P of the Constitution. However, we need climate protection to maintain natural resources, and to quote from Professor Bundy, the Constitutional Court applied a system-level approach, because if there's no climate protection, there are no protection for natural waters, natural environments. We did not focus on the existence or imminence of climate change. Because I'm not sure if there was such a heat or high temperature in Hungary like we are having now or what we had last year. And like last year, you could cross River Tisza on foot around the border where River Tisza enters Hungary, or the salt mine in Paroid in Transylvania is being destroyed due to unexpected weather conditions. And for our international attendees, I would say that this salt mine operated as early as in 1405, which is being destroyed by a small and although flooded stream nowadays, or as we speak. Some people say that there's no climate change, only peculiar weather conditions nowadays, but we accepted that there are different and peculiar weather conditions being apparent nowadays. What is the legal connection between the interest of current and future generations? It's easy and difficult to ask this question. It's easy because the Constitution of Hungary says that the interests of future and current generation must be taken into account equally. So we can say this is a very simple issue. However, if we add a question who the future generations are or who represents them, it's more difficult to answer this question. In Hungary, we are in a lucky situation because we have a representative of future generations, because this is an institution at the level of the Constitution that represents these interests. However, in many cases, these are not provided. And if there's no representative for the future generations, then it's not possible to start or initiate a legal procedure. So this is not an issue related to future generation, but at Hungarian courts there was a serious debate that if a minor below the age of 18 can initiate any cases. And it was a serious question what procedural law can be applied, or as to who may initiate or file a case. Obviously, non-existing generations cannot be a submitter of such claims. So our Constitution says that current and future generation interests must be taken into account equally, but we can only do that if there's an issue that makes this possible. The specific case was an issue like that, so the Constitutional Court was obliged to take into account current and future generations' interests. A principle was stated by the Constitutional Court, or several principles. One of them was the public trust, that the current legislators are the trustees of future generations regarding the assets And the encumbrances must be shared between current and future generations equally. And this was one element of the Constitutional Court decision on which the Constitutional Court based its decision that this law or this act is unconstitutional. Because it was not clarified what load or what burden is placed on the future generation. The representative of the Hungarian government made a statement that the government has already met the commitments that were due in 2030. Another question is that the Constitutional Court had to examine that the principle of banning withdrawal, which is a sacred cow of Hungarian law, and if that can be applied to the climate protection law. So the principle on banning withdrawal, which was a statement or a position taken in 1994, so that you cannot withdraw or reduce the obligations that once had been accepted and adopted. And the legislators have not made any withdrawals since 2020. That was one of the problems that 5 years later the Act included the very same rules and requirements that it had included 5 years before. And actually this law is a half-a-page document, so this legislative provision is a little bit shorter now due to the wise consideration of the Constitutional Court. So this protective level is not the second phase of this procedure. And the Constitutional Court stated that 3 principles should be treated together. One is the principle on the ban on withdrawal. So one was to review if any kind of reduction was applied in case of the first principle. And the second principles or further principles is concentrating on the current status of science and that we have to make every step to prevent any kind of environmental damage. And the rule that was deemed to be adequate 5 years ago is in 2025 is not appropriate to provide any protection for the interests and rights of future generations. And just a little background story to add to this, which is a little ironic, I think. The Constitutional Court recently adopted, we made a reference to the fact that we made an approach, the relevant provision of the climate protection law, just like in the water dam case between Slovakia and Hungary. And it was stated at that time that the provisions, the contractual provisions, were lost their applicability and actually the Chief Justice who was responsible for this issue first met these environmental issues in case of this Börs-Nagymaros, the so-called water dam project, which was actually a failure for Hungary because it could not be built on the Hungarian side. That is why the Constitutional Court annulled the particular provisions of that project. And I'm still talking about Article P, and it's my last thought related to that, that provision on current and future generations and the protection of natural resources for their own sake, all three provisions should have a responsible person. And the simplest case is the current generation's interests and rights, because obviously these representatives of current generations can act on their own behalf. In case of future generations, it's a little bit more complicated, but there are certain standpoints saying that even the representatives of future generations can also make their stance in these issues. There are individuals who regularly submit questions and claims that make actions on behalf of future generations. And there's also an institution in Hungary, a legal framework, who can act for the interest of natural resources, like the 10 national parks in Hungary. So what did the Constitutional Court say in this decision? The emission targets, or the demolition or the withdrawal of these targets, was a symbolic step. However, it is not the most important element of the decision. And from the EU law and from international law, there are stricter and more demanding rules. The Hungarian law or act says that Hungary would decrease 40%, by 40% its emissions. However, the Constitutional Court also noted a gap in the legislator's work, because we are talking about three topics: mitigation, adaptation, and resilience. In Hungarian law, only mitigation is present at the level of laws, and only one half is the reduction of emissions, and its content is still somewhat challengeable or questionable. The Constitutional Court is the most important factor is that it should be a comprehensive application. So mitigation, adaptation, and resilience should be both focused, all three should be focused on, because the directorate of the national parks or the representatives of future generations would only be able to base their claims if they have a legal background that has actual provisions. And the Constitutional Court's decision targets an element or a factor like that. And the Constitutional Court provided 1 year or a little bit longer than 1 year time frame for the legislator to make up for that. And my closing thought is that Article P of the Constitution says that it's everyone and the state's duty to protect these resources. And the Constitutional Court claimed that both the state and the competent institutions and people should have their own share in protecting these assets, even the everyday individual. And later on today, we will have the representatives of NGOs in Hungary who will talk about the facts, what we can do for the sake of environmental protection, so what everyone's responsibility means, and we will focus on that aspect. So this is it briefly from me regarding the decision of the Constitutional Court. Thank you for your attention.
Sándor, thank you very much for your excellent presentation. One of the important characteristics of a conference is to what extent it is able to keep the timing it has been planning as regards the breaks and presentations, and we will expecting this part of the conference to last until 10:35, and it's 10:35. So we have got a little time for a coffee break. I hope you will have the possibility to discuss a lot of questions related to these wonderful presentations in the break. Thank you. So let's continue the session at 11 sharply. I made a big mistake. The wonderful colleagues who were present before should have been given wonderful presents, but I don't know what happened to the presents. You have already received. Well, sometimes you have to let things solve themselves. Then one issue has been solved. Now, I would like to introduce Professor Markus Gehring, who is a fellow of the Lauterbach Center of International Law of the University of Cambridge. He has been a visiting professor in several law faculties around the world, including the Yale Law School. He held a Jean Monnet Research Chair ad personam in Sustainable Development Law at the University of Ottawa. He also serves as lead counsel for Sustainable Trade, Investment and Finance Law with the Center of International Sustainable Development Law. He is the editor of the Cambridge Yearbook of European Legal Studies and co-edits the book series on implementation of sustainable development treaties with Cambridge University Press. I am particularly happy that Professor Gehring is here, and his fascinating topic is implementation of international legal obligations in the EU member states in the field of climate protection, the role of the European Union. Professor Gehring, the floor is yours.
Thank you very much, Professor Sabo, Your Excellencies, Presidents, Justices of the various courts. It's my distinct pleasure to present to you some thoughts on the implementation of international legal obligations with regards to the European Union. Unfortunately, I don't know how to change the slides, actually. Oh, there. Perfect. In the very short time, I will not provide you with a complete answer to the question. I will give you some thoughts and only speak to the slides as a background, but I'm sure that if you're interested, the organizers will make these slides available to you. I spend much of my time on sustainable development, so I will start with that topic and then move into some of the further details. I think it's important to note that in the EU legal order, sustainable development plays a significant role as a leading concept. It's part of Article 3, which legislates the constitutional aims of the European Union. And here you have a part of the text highlighting that the EU as a union shall work for sustainable development of Europe based on economic growth, high competitive social market economy, and a high level of protection and improvement of the quality of the environment. And those who are familiar with the Brundtland Report and the 1992 Rio Summit will immediately recognize the three pillars of sustainable development: environment, economy, and social protection. So sustainable development is a leading concept, and within that leading concept, climate change plays an outside role. I've expressed some thoughts on European constitutional order. I think it's best described as a constitutional order of sovereign states, and the ability to address climate change has been part of the EU's general environmental competence since 1985, but it was specifically introduced into the constitutional text of the European Union in Article 191 TFEU, where the Union commits to promoting measures at the international level that deal with regional and worldwide environmental problems, in particular combating climate change. That distinguishes the European Union from many other international organizations. Having climate change as a constitutional objective, having a mandate to address climate change, makes the European Union very special, and also explains why the European Union cannot commit to an international treaty that seemingly ignores climate change, right? So it makes the European Union legal order very special. We can also highlight that these are not just vague constitutional principles. The European Union, in the form of the European climate law, has acted on the constitutional imperative to address climate change, and when it comes to the interaction with the member states under the energy regulation have a commitment to adopt national energy and climate plans, and these climate plans, while not directly linked to the nationally determined contributions under the Paris Agreement of the EU, still inform what the EU does with regards to Paris implementation of the Paris Agreement. Now, the UNFCCC and the Paris Agreement are international treaties ratified by both the EU and all its member states. Indeed, the high level of ambition displayed in the Paris Agreement negotiations can also be shown by the fact that the European Union deviated from established legal practice. Normally, the EU only ratifies a mixed agreement, i.e. an agreement to which the member states and the European Union are party, after all member states have ratified that particular treaty. But for the Paris Agreement, the Union deviated from that established practice because the EU found it very important to signal that climate change is such a pressing, important problem that the EU wanted to help the Paris Agreement to rapidly enter into force. And in record time, in under 2 years, the Paris Agreement entered into force, even though it has a relatively high implementation and ratification threshold. The EU's nationally determined contribution, right? So that's a bit of a misnomer in the case of the EU, because it's a nationally determined contribution for the EU as a whole, but also for all its member states. So national determined at the member state level, supranational, if you want, at the EU level. And the EU's NDC, the most updated version in 2023, commits to an economy-wide net reduction from the base year of emissions of at least 55% of greenhouse gas emissions. There is a bit of an intellectual, legal question what economy-wide emissions means. It means different things to different people. But if it's the most ambitious interpretation, it would include all economic actors, including consumers. While the precise legal value of the NDC is debatable as a matter of international law, a combination of procedural obligations and the long-term Paris objective, i.e. keeping temperature rises to well below 2 degrees centigrade with a view to achieving 1.5 degrees centigrade, means that a non-regression, and I think the June 4th decision by the Hungarian Constitutional Court also makes reference to that element of non-regression, right? The non-regression is not just in the Hungarian constitution, it's also an obligation under international law. the Paris Agreement is designed with ratcheting up mechanisms in mind. So it makes a less ambitious nationally determined contribution not feasible under that legal framework. And that is important to remember. I don't want to spend too much time on the international legal obligations that the EU has undertaken. It suffices to say that the EU is a full member of the UNFCCC, the UN Framework Convention on Climate Change. And here you can see some of the obligations under the UNFCCC, but we will come back to those tomorrow. It is important to note that there are reporting and transparency requirements in the UNFCCC. And as I explained, the Paris Agreement equally, sometimes it said it doesn't contain any international legal obligations. Please don't, please review carefully before agreeing with that, because while some obligations are procedural in nature, other obligations are actually substantive in nature, and it's the combination of procedural obligations and somewhat milder substantive obligations that make the Paris Agreement truly the constitution of climate change for the world. It's within the ratcheting up mechanism, within successive stock takes that happen at the global level that then have to inform the nationally determined contribution that the Paris Agreement is fully enforced. And I'm very certain we'll debate the advisory opinion by the ICJ, but I think at a minimum the ICJ will refer to the Paris Agreement if you want to fulfill your due diligence obligations to address climate change. I should also, by way of a footnote, highlight that many trade agreements of the European Union now also make reference to the Paris Agreement. So it's no longer just an obligation in international environmental law, it's an obligation in international economic law, which gives added weight to the Paris Agreement. The high watermark of all the EU trade agreements is perhaps the EU-UK TCA, the Trade and Cooperation Agreement with the United Kingdom, so a former member state. It's relatively easy to have a trade agreement with a former member state because all the laws are fully aligned on exit day. On the other hand, it shows you, at least in theory, how far a trade agreement can go. And the TCA not only declares the Paris Agreement an essential element of a trade treaty, i.e. if you need to respect the process by which the Paris Agreement was set up, and any acts or omissions that would materially defeat the object and purpose of the Paris Agreement would trigger this essential element clause and would lead to material breach. There's also a separate definition of the level of climate protection. Now, the level of climate protection is somewhat lower than the respective NDCs, so it is less ambitious in the trade agreement than it is in the nationally determined contribution of either the UK or the EU. But nonetheless, it's a novelty to have that level of climate protection in a trade agreement. And, if I understand the Constitutional Court's decision from yesterday correctly, it also concerned the 2030 target. So that is also an international obligation that the country has. I don't want to spend much more time on carbon pricing because this provision has been triggered 2 weeks ago. So the EU and the UK have agreed on a negotiation process whereby the two emission trading systems, the UK and the EU one are going to be linked. So that doesn't mean the UK participates fully in the ETS like Norway, Iceland, or Switzerland do. It will have a linking agreement, and that will be an international treaty that is somewhat different, but the provision on which this international agreement is based is here on the slide. I already talked about the European climate law. The European climate law is not just regulating the net zero obligation by 2050, it also regulates a process by which EU member states have to report on their progress, right? It's no good for us if we reach 2049 and there's still a massive reduction to be achieved. What we need to act now, and we heard that by the representatives of future generations this morning, we need to start acting now so that we don't lose valuable time, so that the net zero objective by 2050 is actually realistic. And the European climate law, which, by the way, is a regulation, so it's directly applicable in the member states, tries to regulate. There's a lot of controversy in the field that I normally occupy in trade law on CBAM, the border carbon adjustment mechanism. I don't want to sort of put too much emphasis on it, but when it comes to the international relations of the European Union, it tries to achieve climate objectives not just by way of international treaties, but increasingly also autonomous measures, because it regards climate change and progress on climate protection as so important. So what are some of the conclusions of this very short presentation? I think the UNFCCC and the Paris Agreement bind both the EU and its member state. The EU has adopted laws to implement the Paris Agreement and even included Paris Agreement commitments in its international trade and investment treaties, binding both the EU and its member states. EU mechanisms adopted as regulations, such as European climate law, are applicable in the member states as law, and the EU nationally determined contribution includes all member states and constitutes an international declaration serving to fulfill the Paris Agreement obligations. Thank you very much.
Thank you very much, Professor Gehring, for your wonderful presentation. And I now wouldn't like to forget to give our little present. And so far, the Constitutional Court was represented by our acting Chief Justice Attila Horváth and later myself, but three wonderful judges will appear on the podium very soon. The first of them is Justice Ildikó Hörher-Marosi. She serves as justice at the Constitutional Court from 2016. Actually, all of us who are present today started in 2016. Prior to that, he served as a judge for decades, including as a judge of the administrative branch of the Supreme Court of Hungary, where she examined the legality of the state's operations. She worked as a judge in the Ministry of Justice, where she participated in the Euro-Atlantic integration process and then worked in the fields of public law and constitutional law. An important milestone in her professional development was her training at the École Nationale d'Administration in France. She also examined the everyday work of the European Court of Justice in Luxembourg. She is honorary university professor of law. Her main areas of research are the place of the judiciary in the system of separation of powers, the organization and administration of the courts, and the independence of judges. And I would like to add to this that Justice her was very, very active in very important cases related to the environment, and I am extremely happy that I can greet her here. Please, Justice Marosi, take the floor.
Köszönöm szépen a lehetőséget. Sajnálattal kell tájékoztatnom a hallgatóságot, hogy én az
Thank you for the possibility, and I'm sorry to inform the audience that I will hold my presentation in Hungarian, not for the reason what my colleague Mr. Szemesi mentioned, but this is the language that I can undertake professionally more than English, so I would really like to welcome everyone, dear chairman, chairwoman, dear guests, and future representative of future generations, and all my dear colleagues. As it was mentioned in the introductory part, this is not my professional area. Environmental protection is not my professional area. However, I have been taking on these issues within the Constitutional Court. And when I received this invitation to this conference, that I would like to thank you for, by the way, it made me think that environmental protection, organizational issues, public administration issues, these were the topics what I could talk about within 15 minutes. And I arrived to the conclusion that I would like to share with you a few thoughts. In a summary, I prepared my presentation in English. However, it would help you understand in addition to the interpreters. And I would say a few words about the relevant sections of the fundamental law, Hungarian fundamental law. And I actually wanted to talk about the climate-related lawsuits that we received at the Constitutional Court. However, we don't have such lawsuits. I'm sure the Public Administration Court would tell more about it. So the questions of discrimination and similar fundamental rights are not or have not been raised. And Article P, paragraph 1, perhaps serves or provides an explanation for that, as it was mentioned before. And please find or please see Article P, paragraph 1, and in relation to that, I actually underlined the parts that I thought were particularly important in this article. And this is my interpretation, or actually it's the interpretation of the Constitutional Court. This is some kind of a heritage concept that wishes to guarantee continuity and the possibility of handing these down or to the future generations. And along the line of Article P, Constitutional Court wishes to encourage the legislators to make way for fairness and equal treatment for future generation in respect of conservation and nature protection and environmental protection. And as whatever my colleague said, I would like to add that this provision is important, that these are particularly protected assets and values, and this list can be even further enlarged. And I think it's very important that everyone is used in the text, so that everyone is liable, everyone is entitled to protect and maintain resources and values. And my colleague, Mr. Szemesi, I think talked exhaustively about our decision on the climate protection law. And another item, we should not forget, Article P was among the basic principles. As far as fundamental laws are concerned, those are included in Article 21, paragraph 1, and its wording is similar to a former section or article of the law, which reflects the contents and the continuously evolving and applied principle. And just very quickly, if there's a possibility, I would like to go through in light of our future climate lawsuits, as to what this fundamental right framework is, or what it means. Who is the subject of the fundamental right? Everyone except for the state, because fundamental rights concept is that the subjects or individuals need to stand against the state, and the obligors of who are the obligors of the fundamental right, and what is the scope of the fundamental right. It's the state's obligation to maintain the conditions for human life and for natural life and life itself that needs to be guaranteed by the state. And the target or objective of that is to preserve the level of environmental protection that has been existing. And the starting point is the previous assumptions of the law. So these are not values determined by science or scientific considerations. So the Constitutional Court bases its assumptions on the 1994 law and legislation related to environmental protection. Therefore, the legislator is required to work out, to develop a law that guarantees and maintains the existing level of protection. And on the side of the state, this is an institutional protection requirement. And as to what the last element with regards to fundamental rights, the principle of non-derogation within the scope of fundamental law, this is that derogation can be limited if there is another reason within the law that explains this derogation or the limitation. And this quotation that I try to translate into English tries to explain the non-derogation principle. And it's very important to add in terms of Article 21, paragraph 1, that this is not just an institutional protection, but this functions as an as an individual fundamental right, so it is applicable to the claims and complaints to be submitted to the Constitutional Court in the future. So if this is well grounded, a complaint or claim can be submitted to the Constitutional Court, and I think it's important. And what I need to mention as a characterization of the fundamental law, that there's a reversal of burden of proof on the state's side. This is an obligation that it's the state that needs to provide proof when there's a review of the state requirements and obligations. So they need to prove that the level of protection has not diminished, or if it has been decreased, then there's a valid reason for the derogation, and that it was proportionate to the questionable constitutional value, or that makes these values necessary. And another comment to further enlarge the contents of the fundamental right, that this is a universally applicable derogation or limitation. It has a universal nature, so even if, no matter if it's procedural right or organizational related issues, we still have to apply the non-derogation factor and principle. And now that, with that said, I would like to mention the most important milestones of two decisions as to how these were applied by affecting or touching upon organizational issues or review of organizational issues, how the Constitutional Court practically applied these principles. The first case was affecting national parks. Perhaps it has been already mentioned. And in the first case, it was a decision in 2015 raised by an initiative of the President of the Republic, that the directorates of the national parks that were created for maintaining natural assets, and these within that circle, Natura 2000 areas and other agricultural areas would have been handed over to certain authorities, and it would have entailed the reclassification of competencies. We can see what is it concurrent with, or what environmental interests fall together with the economy, obviously, because the authorities or state bodies where these organizations' asset management activities would have been handed over, these authorities were not obliged at that time to take into consideration the environmental aspects of these activities and the activities of these national parks. Violating the principle of non-derogation, I would like to step back a little bit. So how this situation was resolved by the Constitutional Court, that by dogmatically applying the non-derogation principle. So first we examined if Article P and Article 21 was applicable to this issue, and we had to examine that if there was any step back that we could see based on the previous legislation, and it was the court said yes to this, because if we are talking about economic management or an institution for economic gains and being responsible for these national parks, they would not be concerned with the environmental aspects of these national parks or organizations. Therefore, the reduction in responsibility was established by the court. Therefore, the state body involved could not make any reference or provide any evidence that would have underlined the reasons for this derogation. Therefore, we accepted and accepted the President of the Republic's initiative, and we annulled the decision to hand over these national parks to certain state bodies. The other case is from 2019, and the environmental and nature preservation the integration of these authorities on a county level. Perhaps it's a little complicated, and this chart is not a comprehensive chart. Perhaps it needs a little explanation. The green highlighted institutions, Ministry of Interior, these are general authorities with general scope of liabilities, whereas in parallel to this, in parallel to the generic institutions, there was a professional organization, the Ministry of Agriculture, and whenever area usage processes were involved, then within the framework of the general administrative framework, they had to look for or contact the specialized authorities to make a suggestion or a recommendation. So they had to work together, and the generic authority had to integrate the recommendations and suggestions of the specialized authorities. As a result of this integration, actually the blue highlighted chart disappeared. However, the sectorial interest did not disappear. That was recommended for reclassification, rearrangement under the local or regional public administration bodies. So it was examined, the area usage issues were examined as a professional issue and not as a public specialized administrative responsibility. This chart shows the integration, actually. The government office, which is a general local public administration institution, and you can see that what authorities belong to that framework. That's where environmental protection and nature protection sectorial issues are considered, and they made some kind of a decision. And when resolutions and decisions are made, this environmental protection requirement is just one of the aspects and criteria to be considered. And opposition MPs challenged this regulation or regulatory framework and took this issue to the Constitutional Court. And the Constitutional Court considered or relied on Article P and Article 21 because it is an interesting question as to what Article P is applicable to and what, in which case, fundamental right rules should be applied. But I think these two articles create an environmental framework on which the Constitutional Court can rely its decisions. However, coming back to this organizational restructuring, the court established that Article P, paragraph 1, that this restructuring falls under that competence. However, it was stated that environmental values and making way to those, it cannot depend on the organizational framework under which the relevant decisions are made. And these issues should be enforced and should be controlled by the Constitutional Court or audited by the Constitutional Court. So the organizational question and the change in the organization should not result in a derogation or a step back from the previous standards. But the decision is not finished or was not finished there because the Constitutional Court noted that the decision of the professional authority had to be integrated into the general authority's decision. However, we did not have this kind of a legislative rule. Therefore, it was required that between competing interests, always environmental protection requirements should be given priority. No financial, economic, or business interest should override the environmental and nature conservation interests and requirements. So this was one finding or decision of the court. And there was also another decision taken by the body of the Constitutional Court that there was a circumvention of the law. Therefore, it provided for the Parliament to restore the previous level of standards and norms. Therefore, they obliged the general public administration level that in case a decision is made on the usage of certain lands and areas, that they need to consider the environmental aspects of the permitted or licensed activities. And actually, the Parliament made up for this indulgency, and even if not at the level of the procedural rules, but they added this to the material law framework, and then it still is a valid procedural rule, even if it's a material law legislation. The legislation itself may be constitutional. So there was a debate amongst experts if this Constitutional Court decision is applicable or not, it is properly usable or practicable. And there's an epilogue. I should step back again. My last slide is that when I worked as a justice in the public administration court, that every decision was as much as you can enforce of it. So as much as the parties are willing to enforce, and I still think the same way as a justice of the Constitutional Court, that the provisions of the fundamental law has the potential to hand over as a common heritage to future generations, but I think the Constitutional Court between 2017, 18, and 19, obviously the year 2025 is an exceptional year, but I think the interpretation of this constitutional provision had a renaissance, a revival area. Of course, we need to see, or we need to note, thanks to Mr. Marcel Szabó and Mr. Szemesi, that I don't think we should pat our shoulders that these two previous cases highlights that environmental interest is always a competing factor, and there are always other interests against which the environmental interests must compete and must be enforced. In the short term, I'm not very optimistic. On the long run, maybe I might have a more optimistic view as for the sake of humanity. Thank you for your attention.
Thank you very much, Justice Marosi, for your fascinating and very informative presentation. And our next speaker is going to be Professor and Justice Balázs Sanda, who is Professor of Constitutional Law of Pázmány Péter Catholic University, and at the same time, Justice of the Constitutional Court. His main areas of research are religious freedom and the role of values in constitutional law. Justice Sanda was the dean of our university from 2010 to 2013. Since 2016, he has been a justice at the Constitutional Court. He is rapporteur judge in cases relating to freedom of religion and freedom of expression. And today, the title of his presentation is Mainstreaming Future Generations, the Constitutional Vision of the Human Person. Professor Sanda, please take the floor.
Thank you. That's embarrassing. I made a few slides that I usually don't do, but I didn't use colors because colors are endangering the environment. That's it. Wonderful. I have to bear the time limit in mind. All of you in this room know Marcel very well, and he's I've known him for a couple of decades. I will not share the time frame here. I never liked his working methods, but I greatly appreciate his success and what he achieves with the methods he uses. Using these methods, some of you may be aware of, he convinced me to speak on this conference. I don't consider myself to be an expert in climate issues or environment, but his persistence was so convincing, and he asked me to to speak in English or something like English. Hunglish, that's our working language. A few weeks ago at a conference, a dear colleague of mine introduced me to a foreign colleague as her favorite Constitutional Court judge. And I told her that, well, one can have a favorite composer or a favorite singer, but you can't have a favorite judge. But to be honest, I have some favorite judges on the Constitutional Court, and it's an additional embarrassment that I have to speak after one of my favorites and before another favorite, just to give a start. The fundamental law begins with a long preamble, and of course preambles may be dividing. Preambles sometimes are called as literature or poetry. In themselves, they don't have a normative character, but certainly preambles are important, and very often in constitutional debates, when adopting new constitutions. Remember the debate at the European Convent on the Constitutional Treaty of the European Union. The preamble was the most debated issue. Sentences, wording of the preamble. In the preamble, in this national law, well, as the preamble is entitled, we have a couple of remarks with regard to environment and nature and the values of them. But when we come to the normative text, Justice Moroshi has just pointed to Article P, that is in itself just a goal of the state. It's not a fundamental right, but it's a state obligation to protect environment, to safeguard natural resources, and to preserve them for future generations. Future generations that are, not born yet. They are still, hopes of our families or our society. When it comes to the normative text, and I failed to speak with Justice Moroshi before our conference, but among the fundamental rights, Article 20 and Article 21 make important references to nature and environment. Concerning the right to health, one of the elements, among others, is that we should provide for health by ensuring the protection of environment. It's not just about healthy food and water. It's not about health food, but healthy food. It's not the same. But also environment has to be provided for the sake of health. And then we arrive to Article 21 that has already been mentioned concerning the right to a healthy environment. And here I should come to a number of further considerations on constitutional innovations we have. One of our constitutional innovations is present in this hall, Commissioner Bandi, who is the commissioner, the speaker for interests of future generations. Future generations as such, and here the wording may be of interest, have no rights. You have to be born to have rights, but they have interests. And this has been recognized in an institutional way to safeguard the interests of future generations and to provide for an institutional protection, an institutional mechanism for the sake of their interests. Of course, one could enter into a long debate whether the methodology the fundamental law provides for and the statute on future generation provides for is sufficient or not. I will not go into detail here. Just I wanted to refer to the innovation the Hungarian system has in this respect. Another remarkable innovation has been debated back at the drafting of the Fundamental Law, 2011. And that is a very dividing topic, the system of parental proxy voting for minors, the right to vote for minors. Certainly, it's not about future generations. Minors are already citizens. They are born, but they are deprived from their right to vote. In the drafting process of the Fundamental Law, the idea was rejected. Maybe it was not brought to the discussion in a way that had helped its adoption. It certainly had to change a paradigm on electoral rights, but we shouldn't forget that for centuries we had very different paradigms on electoral procedures. In the 1900s, suffrage for women was considered to be an insane idea. And we still celebrate the heroes of 19th century liberalism, but none of them argued for suffrage for women. To the contrary, they regarded it as a dangerous idea. And now, to the contrary, it would be insane to say that women should have no voting rights. We have to turn the question around. The real question is not why we should grant voting rights to children, but the real question is much more why they don't have one. Certainly they don't have one as they couldn't exercise it. A few countries, including Austria, that is not that far from us, has lowered the suffrage age to 16. Regarding these teenagers capable to exercise political rights. Ideas of that kind may sound very strange. They challenge a consensus, but I think that a future-oriented constitutional system shouldn't be scared to raise innovative ideas. And one of them could be to recognize parental rights as we recognize parental rights in all other aspects. Parents can decide on the name of the child, on sexual education, on religion, education, etc. Why don't we grant them the right to cast a ballot on behalf of their children? Certainly, as long as there is a consensus on values in a society, maybe putting more political weight or granting more political weight for parents raising kids, to take the burden of raising kids, wouldn't be a necessity. Because grandparents by nature are always ready to make sacrifices for their grandchildren. But when we don't have a value consensus in a society, and a growing proportion of grown-up citizens have no children, and they willingly have no children. It's not an accident, but a decision, maybe a value-based decision. Then providing more emphasis or providing the due emphasis to the rights, to the interests of minors, citizens who are still minors, maybe isn't that shocking as it would look at the first glance. To cut short a misunderstanding, the one man, one vote principle cannot be challenged. A parent, just for raising a child, cannot have a second vote. But what the idea is about is to grant the right to vote to the child, exercised by the parent, and that's something completely different. I only wanted to throw the idea to the table, to the discussion, as and to come back to the fundamental law. That in the national law has a very positive vision on the future generations, and some of them, as the wording may suggest, may not be born yet. Personally, I have no grandchildren yet, and in my case, this is fortunate that I don't have grandchildren yet. In other cases, it would be maybe a misfortune. It may sound appealing, a sentence that is appealing to the future, and that is certainly of interest, and I will come back to the sentence in a moment. The cornerstone of our system of fundamental rights is based on the protection of human dignity. And a part of human dignity is the right to possess over property, including or connected to the right to decide on earthly possessions in case of death. So you can decide on inheritance. But when it comes to inheritance, then our legal system limits the right to make a testimony, to safeguard the rights of descendants, eventually to safeguard the rights of spouses, and in the most unfortunate situation, to safeguard the rights of parents. That's a mandatory share, köteles rész in Hungarian, that is not subject of our right to dispose on our property when we write our testament. Maybe the analogy is a remote one, but probably when this bond between generations has to be set up, then in the framework of this bond, our legal system in private law has this very specific aspect of making a compromise between individual rights and the freedom to make our own decisions on our possessions and our responsibility, financial responsibility, towards our descendants, let's say, in most cases. Analogies are certainly always dangerous and misleading, but a similar analogy is probably due in environmental issues. Certainly, we have our rights, and we can use the environment, the nature, as much as we need to use of it. But it's not just a moral responsibility that we leave a part of it, a due part of it, to the next generations. The generational bond goes both ways. We are responsible to our descendants. We have to leave a livable planet to them, and we expect them to find new, more effective ways to combat the challenges we leave to them. Possibly they should combat them in our lifetime, please. They should fight cancer, they should fight pollution, climate change, and more. Setting signs to protect our environment is essential. But more so, investing into education, into future generations, is the crucial point. Their innovation should solve problems, maybe all problems, we have left behind. So the best way to heal personal and social trauma, to heal the damage we have caused and leave in environment, is to have a future generation, to have children, to have grandchildren, to motivate them and to bring them up in a way that they should be fit to tackle all the challenges we leave for them. Thank you for your attention.
Thank you very much, Justice Shanda, for your very interesting presentation. It's also additional purpose for my life. I would like to be one of your favorite judges one day in the future. We are friends for a long time. It's just a joke. So, dear ladies and gentlemen, our next speaker will be Justice Professor Réka Varga, Dean, who is going to speak about a fascinating topic a little bit further away from the daily problems of this presentation, but very much related to climate. The title of his presentation will be Climate Destruction During Wartime, a fascinatingly interesting international law topic. Let me introduce Justice Réka Varga shortly. Réka Varga is Justice at the Constitutional Court of Hungary from 2023, and she's an Associate Professor of Law at the Pázmány Péter Catholic University. She is also Dean of the Faculty of Political Science and International Studies of the National University of Public Service. Her main areas of research are the law of war and international criminal law. From 2001 to 2009, she was legal advisor to the International Committee of the Red Cross and then head of the International Law Department of the Ministry of Foreign Affairs, and subsequently Secretary General of the Office of the Commissioner for the Fundamental Rights. She is a former member of the International Humanitarian Fact-Finding Commission, and between 2016 and 2019, she represented Hungary in the EU Council's Working Group on International Law, the Council of Europe's Committee of International Legal Advisors, and the UN's Sixth Legal Committee. And also, she's also a member of the Permanent Court of Arbitration. Justice Réka Varga, please take the floor.
So thank you very much, Professor Marcel Szabó, for the invitation. Mr. President, Mr. and Mrs. Justices, dear Mr. Deputy Ombudsman. Even though I serve as a justice at the Constitutional Court in my free time, I'm an international lawyer dealing with international humanitarian law and the law of war. I'm not an environmental law specialist, not in international law either, but I do deal with wars a lot. And so preparing for this presentation, I was trying to think of ways IHL, international humanitarian law, could protect the natural environment and could positively affect destructive role armed conflicts play in climate change as well. And just to respond to the introduction of Justice Szabó, it is a subject of every day because we have a lot of wars around, and we can feel this in the past couple of years very much in this region as well. And there is a very strong effect and retro effect between armed conflicts and climate or the natural environment. Now, just to say a kind of some shocking facts. So 12 of the 20 countries which are the most vulnerable to climate change are also sites of armed conflicts. So there may be also statistically a link between armed conflicts and climate change. And climate change or climate destruction has been seen and is as a contributing factor or a multiplying factor for armed conflicts. It's not the only factor, but it is a multiplying factor. Just to tell you two short examples, the eruption of the Syrian conflict had a lot of reasons to it, but there was a multi-year drought in Syria during 2006 to 2010, which led to a widespread crop failures and livestock die-offs. It resulted in up to 1.5 million rural Syrians who were driven off their land, so a massive movement of people. Consequently, there was a high unemployment, food insecurity, competition for natural resources. Consequently, a discontent with the government being able to handle the crisis. And again, I'm not saying this was the factor for the eruption of the Syrian war, but inevitably it was one of the factors leading up to the civil war, which in turn has a devastating effect on the environment and on climate change. And another example may be the Lake Chad Basin, where that area has faced a combination of environmental change and conflict in a very vicious circle. The Lake Chad has dramatically fluctuated because of climate change, that degraded farmland, that deepened poverty, and again, the cycle goes on and on and on. And of course, there is no mistake that this coincided with the rise of Boko Haram, and we know the story. So there is inevitably a kind of a cycle or a relationship between armed conflicts and the protection of the natural environment and climate change. Also, if you think of how wars or armed conflicts contribute to destruction of the environment, just think of the amount of the bad influence of the production itself, the production of weapons that are used for armed conflicts, but also if you think of the devastation that armed conflicts cause, and then the need to rebuild. So just think of houses made of concrete being demolished, and then they have to be rebuilt. All of them have a very strong ecological degrading effect. And the development of weapons, which is really accelerating, has both good and bad effects. They are more far-reaching and more devastating, but also they can be more precise, which could lead to a positive effect in the destruction in the natural environment. So there is a double vulnerability going on between climate change, effects on the natural environment, and armed conflicts. I wouldn't like to bore anyone with detailed rules in international humanitarian law on the protection of natural environment. There is no talk about the climate itself. These rules are relatively old. So IHR rules say natural environment. Basically, there are certain rules that protect works and installations containing dangerous forces, typically dams, dikes, or nuclear power plants, but anything else that could be harmful. And there is a prohibition on attacks which would result in severe losses among the civilian population by releasing these dangerous forces. Even though there is a clear prohibition in international humanitarian law, this is not without example or not without exceptions, because if there is a military use for these objects, then an attack could become legal. There's also a very general protection in humanitarian law on the natural environment, but it's a very soft one because it says care shall be taken to protect the natural environment against widespread, long-term, and severe damage. Care shall be taken. And if you just see, some of the examples are listed, and non-exhaustive examples I have listed on the right. If you just think of the firing of the oil wells, I think that was all kind of like froze into our minds as a result of the Gulf War, or the bombing of the Pančevo industrial complex in Belgrade as a result of the NATO bombing, or lots of other examples with oil spills and bombing sulfur plants, for example, by ISIS, or just most recently in the conflict in Ukraine, not only the Zaporizhzhia nuclear power plant, but also Ukrainian authorities made a calculation of more than $55 billion worth of environmental destruction going on in Ukraine. And again, it's not only the Zaporizhzhia nuclear power station, but it's also nature reserves and all those being threatened or disrupted by the war. There is also one specific convention, and I must say that it's a very weak convention, which was a result or more an outcry after the 1970s environmental modification techniques used mostly by the United States, mostly in Vietnam, but not only, and it was also an agreement between a deal between the US and the USSR in the framework of the arms control efforts, where states adopted an environmental modification convention, so the Convention on the Prohibition of Military or any other hostile use of environmental modification techniques. The reason it sounds very nice. The reason I'm saying it's a weak convention is that there are only 78 states parties to it who actually, they have been responsible for approximately 83% of the world's CO2 emissions. So again, we could be very happy, we should be very happy, it's just this convention is not really used. Truth being told, environmental modification techniques haven't been used, or not to that extent, since. I wish I could say it's because of the convention. I don't know, let's be optimistic. And just before I turn to how I think these rules can be better applied in the favor of climate change, I just wanted to highlight some of the responses of international organizations and humanitarian organizations to environmental concerns. Now, the activities of humanitarian organizations in a given crisis is always prioritized, and the first number one priority is always life and security. That always comes first. Long-term, the protection of the environment could come in the longer-term priorities, but again, it's a priority, it's a lower-level priority. Some organizations have adopted operational measures such as saving satellite images to document damage in case a national or international criminal procedure would come up, or providing post-conflict environmental assessment, or, for example, the International Committee of the Red Cross having a lot of activities on replacing and restoring water supplies, waste management, reduce water contamination, etc., etc. There are also a number of measures and guidelines adopted, but they are all soft law documents. They are more to raise awareness on the issue. But again, in an armed conflict, number one priority is protection of the life, and issues such as protection of the environment, which have a long-term effect, but in the immediate priority, they come very low in the priority list. This is just how it functions. I just also wanted to show that there are certain efforts by the International Criminal Court to take into consideration the environmental aspects of armed conflicts. What I think is a very forward-looking or forward-looking initiative is the initiative of the prosecutor of the International Criminal Court, who adopted a guideline for promoting accountability for environmental crimes. It's a draft policy, basically, and it includes a specialized training for ICC staff members to better direct and investigate and prosecute environmental crimes, which is very, very useful if you want to have these kinds of crimes in front of the ICC. And it wants to expand its in-house expertise by recruiting environmental specialists and related specialists who would provide expertise in these kinds of cases. Some of the Pacific islands have tabled a proposal to include ecocide in the list of crimes of the ICC. Having been active for the past 25 years in the practice of international law, I don't see it coming very, very soon, but already tabling the proposal I think has a lot of potential in it. And now coming to the main message of my presentation, or my short intervention, is how could the existing use of humanitarian law and international law more broadly be better applied to tackle the issue of climate change and protect the natural environment. There are certain ideas, for example, to include the existing, or to make the existing international legal instruments applicable in wartime, applicable in armed conflict, not only the human rights instruments, but other kinds of instruments, which may be a good initiative, but again, it doesn't seem to be very realistic for me. There is an initiative to include environmental considerations in military manuals. This is important because when military go to war, they rely on their military manuals, and military being the military, whatever is in the military manuals is God itself, so they have to follow that. So that already, and I listed some countries and the NATO having environmental considerations in their military manuals. There was also an idea, especially by 2 countries, on the idea of establishing protected zones for specially protected sites in armed conflict, but again, there was the will to apply it. Now, having worked a lot with the military in the past 2+ decades, if you think how a military acts in an armed conflict, their #1 priority is to win the war, or win, be effective in that given operation, and to save their own troops. These are the #1 priorities. If you come up to a military commander and say, natural environment, save the natural environment, they will just smile at you and just, say goodbye. And this is why I think that if you want to make these rules stronger or be strongly applied, we have to think with that logic. And my proposition or my idea is to use the existing framework of international humanitarian law, the existing laws and regulations the military commanders have to already consider, and this would be the protection afforded to civilians and civilian objects. And when I say that the #1 priority is always to save lives, if you go from that angle, maybe you can have it kind of infiltrated in the military commanders' minds to say, there is a rule in international humanitarian law to say that when you carry out an attack, you have to make a distinction between combatants and civilians, military objects and civilian objects. And if you carry out an attack, you have to suspend the attack if it becomes apparent that the civilian damage, including damage in civilian objects, is disproportionate or unproportionate to the military advantage anticipated. This is what we call the proportionality principle. Now, traditionally, when these rules were drafted, by civilian objects, they meant houses, schools, normal civilian objects. They didn't, natural environment wasn't implied. But who says it cannot be implied? And this is where you can bring into the already existing knowledge, already existing logic, considerations of natural environment and protection of the climate to say that you could include and you have to include in the distinction assessment and in the proportionality assessment that is known to every military commander because they don't want to go to jail. So they have their legal advisors close to them who advise them on these issues. And that, for me, would be a more effective way to include these considerations to say that in the proportionality assessment, when they weigh the military advantage that they want to reach with the damage in civilian objects, including the damage in the natural environment, which actually, directly or indirectly, does have an effect on civilian lives, because in the long term, it will have an effect on the livelihood, on the security, on the food and everything that the civilians rely on, so that they have to bring in the environmental considerations in the proportionality assessment. And again, this is a logic that they are familiar with, and this is a logic that they already know. So this is something I came up with. Thank you very much for the invitation so that I could come up with this idea. I know I'm the only thing between you and the lunch, so I will especially thank you for your attention, and it's not for me to say enjoy lunch, but I can. Thank you very much.
Justice Varga. Thank you very much for your fascinating presentation. And we reached a landmark in our conference because lunch is coming. We should continue at 1:20 according to the schedule. Those who are part of the lecturers, those who have made presentations are kindly requested to join this little room where lunch is served, and wonderful buffet lunch is served just outside of this wonderful hall. So see you back at 1:20 at the hall.
kéne hallani.
The afternoon panel of this conference. Thank you very much for joining us, waiting us, and we hope that the afternoon panel will be as much interesting as the morning panel. Our first speaker just arrived from Oslo, Professor Kristina Voigt from the University of Oslo, Norway. She is a renowned expert in international environmental law. She is passionate about legal issues of climate change, environmental multilateralism, and sustainability. Professor Voigt has published widely on these topics and is frequent speaker on international and national events like our conference today. Professor Voigt is a chair of the International Union for Conservation of Nature World Commission on Environmental Law. For more than 10 years, she also worked as legal advisor and negotiator for the government of Norway in the UN climate negotiations, and she's currently the first co-chair of the Paris Agreement's Compliance and Implementation Committee. Professor Voigt, the floor is yours.
Thank you so much for this very kind introduction. And it's indeed true. I just arrived like 5 minutes ago, 10 minutes ago, so I apologize for not having been here this morning. I know I missed a number of really wonderful interventions, but I'm glad to be here, at least in time for my own presentation. I would also like to thank very much the Catholic University, the Constitutional Court of Hungary, and the National Council for Sustainable Development for putting together this really wonderful conference. I work a lot on the interface between the judiciary and academia and policy making, and I see some very good friends here and colleagues in the room who do the same. And I know there are not that many fora where they all can meet and exchange and speak freely and learn from each other. And for that reason, I'm very grateful for this event and for the invitation. Now, what I will be speaking about is a very recent phenomenon, and that is that climate change litigation, which you have heard about quite a lot already and will hear more the rest of today and tomorrow, that climate change litigation has reached the level of international courts. I know you already talked about the regional human rights court, in particular the European Court on Human Rights, in the Klimasenioren judgment from last year, but I will be focusing on international courts where climate change advisory proceedings are currently pending, at least in front of 3 courts, and 1 is already rendered. Now I have to see how I can navigate here through my slides. I have to click or do something. Oh, there. Ah, okay. Thank you so much. So what I will start with is to describe international climate law, from which a lot of national climate law derives, either through implementation or through using international law as a means of interpretation. That international climate law, I'm sorry. Is some oh yeah, that happens when you just arrive. That international climate law resembles a puzzle, an unfinished puzzle, and I'll talk a little bit about this. And then I'll talk about that turn to international courts, and I give you the 4 examples that currently are out there. And then I would like to share some of my own reflections on risks, on benefits, and expectations towards these international proceedings. Well, this is the puzzle. Why do I talk about a puzzle? Because we have some pieces in place, like the UN treaties on climate change, the United Nations Framework Convention on Climate Change, its Kyoto Protocol, which is becoming less and less relevant, and of course, the Paris Agreement, which has been very influential in driving climate litigation and in informing judges worldwide in the interpretation of, for example, constitutional norms or human rights norms. But it's an incomplete picture. These treaties that we have are no silver bullet. they cannot give all the answers to every single problem related with climate change. And there are some pieces, or actually quite a lot of pieces, missing. We do have a general picture of what we would like to see, but it's not complete. Now, currently, there are no negotiations ongoing internationally that would fill these missing pieces through yet another treaty, which means that the missing pieces are currently filled one by one through treaty interpretation by international courts. Treaty interpretation, in particular interpretation of treaties that from the outset were not adopted with having climate change in mind, for example, human rights treaties or the law of the sea, and as well by customary international law, which is currently part of what the International Court of Justice is elaborating how it fits into our puzzle on climate change. Now, against that puzzle, as I just said, we see that turn to international courts. These are requests for clarification or answering questions on international law that we see coming towards international courts. And I'm talking about basically United Nations courts like the International Tribunal of the Sea and the International Court of Justice, but we also have regional human rights courts that are involved in filling this puzzle. I will not talk about contentious proceedings because you already heard quite a bit about the cases decided by the European Court on Human Rights. I only mention that this court has been and will be engaged in quite a lot of climate change cases, but we see also human rights treaty bodies, human rights committee or the Committee on the Rights of the Child increasingly engaged in giving or providing answers to certain normative questions. Now I'll focus on this little piece, international courts, and I'll just show you some of the pieces that are missing when I talk about this puzzle of international law. One very fundamental question that you would think the UN climate treaties might answer, but don't really, is what are the substantive, the material obligations of states to protect the climate system or to reduce greenhouse gas emissions? In answering this question, we only get certain indications from the UN climate treaties, but no comprehensive answer. And if there are obligations, do they differ for different states, or they all have the same obligation? And what are the consequences if there's a violation of such an obligation, if it exists? What are the obligations towards future generations? Does the law of the sea require climate action? Well, there we actually got an answer, and I will show it to you. What are human rights obligations with respect to climate change? And if they exist, do they apply extraterritorially? Because in many cases, the people suffering the most are people in places and in countries that have contributed the least to the climate crisis. So if there are human rights violations, for example, people living in the low island states or low coastal countries like Bangladesh, if they have to leave their countries, if their homesteads, can that somehow be linked to human rights obligations, for example, of high emitting states? Or is it only a vertical obligations of the states towards the people on its own territory? These are open questions under international law, which cannot entirely be answered by just looking at the climate treaties. These are questions that are currently put to international courts. And you can perhaps perceive already that the answers by these courts, even if the answers come through advisory opinions which are not legally binding per se, may have a very important normative influence for other courts, including domestic courts. There are 4 requests currently to 4 different international courts. Actually, I filled the 4th one in while I was on the plane here because there is so much happening that it's sometimes breathtaking just to keep up with all the developments. But we had a request to the International Tribunal on the Law of the Sea, a court in Hamburg which has jurisdiction over the United Nations Convention on the Law of the Sea. And we have a request to the Inter-American Court on Human Rights, which has jurisdiction over the American Charter, not Convention, on Convention on Human Rights, I'm sorry. We have a very current request just for May this year to the African Court on Human and People's Rights, which has jurisdiction over the African Charter, that's the Charter, on Human and People's Rights. And of course, we have a request to the International Court of Justice in The Hague. So these 4 proceedings are ongoing. The first one is decided. I'll mention that very briefly. But this gives you an idea of what's currently happening out there in international law. With respect to climate change, and again, these are attempts to fill pieces of that puzzle that I showed you in the very beginning. Now, very briefly, on the International Tribunal for the Law of the Sea, which received a request for an advisory opinion about 3 years ago. The request came not as a surprise from very small island states, small island developing states, Antigua, Barbuda, and Tuvalu, who established an international organization called COSIS and requested the court to answer 2 questions. I'll show you in the next slide which they were. The hearings took place in September in Hamburg at the court's seat, and for the court, these were the biggest proceedings the court had ever experienced. And the opinion that the court rendered is about 1 year old. It came out in May last year. Now, I see that my slides have been mixed up. Can I switch to the PDF file? This happens sometimes if you use a PowerPoint. No, I just want to switch to the PDF. And I just keep on talking not to lose any time. So the request, just for you. It seems to be a little bit mixed up, but I know what was there initially, and I can. So the questions put to the International Tribunal on Law of the Sea concerned a particular interpretation of the United Nations Convention on the Law of the Sea, which was adopted in 1982 at a time when climate change didn't feature in international treaty making. Now, the court was asked how the obligations under the convention, in particular to prevent, reduce, and control pollution of the marine environment and protect and preserve the marine environment, how these obligations need to be understood in the context of anthropogenic greenhouse gas emissions and climate change impacts on the marine environment. Now, the court answered this question. This was our little delegation. The IUCN participated in the proceedings, and the court answered this question, or these 2 questions, 1 year ago by saying very clearly, and that's a very important statement, that anthropogenic greenhouse gas emissions are pollution of the marine environment. I think this is a finding that still perhaps needs to be broken down on what that means for domestic legal system. It follows from there that the obligations of the Convention apply to all its parties, and that is the obligation to prevent, reduce, and control pollution of the marine environment and to protect and preserve the marine environment. These are obligations of due diligence, which are not obligations of result, but basically states need to put into their best efforts in complying with these obligations. The core of your obligation is to take all necessary measures, and in deciding what necessary measures are, the court used the Paris Agreement in the interpretation of UNCLOS, which is very important because we have here an international tribunal with a particular competence, particular jurisdiction over the United Nations Law of the Sea Convention. So from the outset, that court has nothing to do with the Paris Agreement. That's a different international treaty. But in order to create harmony and to a certain extent consistency in international law, it used the Paris Agreement in the interpretation of the obligations under UNCLOS, and basically said that in order to fulfill the obligations under the Law of the Sea Conventions, all parties have to reach net zero greenhouse gas emissions by 2050. So this is a very important step that this court took, which I will come back, hopefully, if my slides work, in the context of the other courts. The second, and still currently pending advisory proceeding, is from the Inter-American Court on Human Rights, which received a request from two countries, from Colombia and Chile. And you may ask, why are we here talking about the Inter-American Court on Human Rights? We are in Europe, we have the European Court on Human Rights, this court is far away in Costa Rica. But you may know that this court traditionally has been very progressive in linking human rights and the environment, and in establishing that there is a human right to a healthy environment, at least in the context of the Inter-American system. And that had repercussions when, for example, the Human Rights Council and the United Nations General Assembly, through their resolutions, established that there is a human right to a clean, healthy, and sustainable environment. That was partly based on the practice of the Inter-American Court on Human Rights. Now, this court had hearings 1 year ago, and we don't have the advisory opinion yet, but I'm pretty sure it will be out soon, and it will be one of the most progressive statements, authoritative statements by an international, by a regional human rights court on the climate emergency and the linkage to human rights. The third pending advisory opinion, it's the newest one, is from the African Court on Human and People's Rights. This is a request from just earlier this month, but it is following that same logic, that there is a need to also interpret the African Charter on Human and People's Rights in the context of climate change. Again, another international treaty which was adopted at the time when climate change wasn't yet a concern. And the request by the petitioners, that's the Pan-African Lawyers Union, a civil society organization, is to interpret that charter in the climate change context. But importantly, that charter actually in Article 24 recognizes that all peoples shall have the right to a general satisfactory environment favorable to their development. It's still open what that means in the context of climate change, but it's definitely a different starting point than, for example, the European Convention on Human Rights, which doesn't have anything even closely like this. Just very quickly, these are some of the questions, but you can see they deal with the interpretation of the African Charter in the context of human rights, particular positive obligations to protect vulnerable people, also the question of what then is the status on compensation for loss and damage and reparation, and the final question, are there responsibility towards other states to ensure that international regional treaties on climate change are respected? And that's the hint to the Paris Agreement, which is going to be very interesting to see how that court is going to deal with this. Now, the final court, and yeah, the pictures, you just ignore them, they've all been mixed up. But the final case, of course, is the request to the highest judicial organ in the UN system, the request to the International Court of Justice. That request came from the United Nations General Assembly about a little bit more than a year ago. Interestingly, that resolution was adopted by consensus, something that nobody really expected, but did happen. It's based on an initiative by Vanuatu, again a small island developing state, and the questions to the court, sorry, that's all completely mixed up. are what are the obligations of states under international law to protect the climate system and other parts of the environment against anthropogenic greenhouse gas emissions for present and future generations. Right? You can already see this is a fundamental question in international law now put to the ICJ. And the second question, only two questions, the second question deals with the legal consequences if these obligations lead to harm to the climate system. So these are two core questions in our puzzle of international law that are now lying in front of the judges of the International Court of Justice. And I'll just try to navigate through the rest of my slides because that was not to be just that one picture. The proceedings started last year with the hearings taking place over 2 weeks right before Christmas. Maybe some of you have followed the proceedings, they're all available online, but these proceedings were historic. They were historic for several reasons. First of all, also before this court, there's never been a bigger case. There have never been more participating states and international organizations. Altogether, there were 110 interventions that were made in the course of those two weeks last December. And the judges and the registrar, and I talked to them, they said they've never seen anything like this. And I think they were a little bit overwhelmed by the number of participating states and organizations. It is also the very first time that the International Court of Justice deals with climate change. That court has never said anything about climate change, and it's going to be very interesting to see what the answers are to those two very fundamental questions. And the third point why this is historic is that it's also the first time for many small island states that they're even in contact with that court. Many of them had never been to the ICJ, and they needed to work up their competence on how proceedings look like. But it shows or speaks to the importance of these proceedings that it attracted so many participants. The advisory opinion is expected sometime this year. I get all sorts of indications, maybe June, maybe July, maybe after summer, but sometime this year. I think that's what we can see. Maybe you know more about this. But we hope to see the ICJ telling. There are very different expectations to these proceedings. If you had the chance to listen a little bit of what states argued, you will see that's a huge canvas of completely different arguments. And they range from the left side here, where some states argue that the climate treaties are completely irrelevant, they don't help at all, we need to focus entirely on customary international law, in particular the principle of prohibition of significant harm to other states and to areas beyond national jurisdiction. And on the right side, there were some states that said the climate treaties, Framework Convention, Paris Agreement, they're all theirs. Nothing else matters. They are lex specialis. They set aside anything else in international law. I do think that the right answer lies somewhere in the middle, that the climate treaties are perhaps considered the primary legal instruments, but that also other international law, law of the sea, human rights, customary international law apply, and that they need to be interpreted in the light of especially the Paris Agreement temperature goal. But this is an interesting scenario where, because there were so many states, the arguments really differ in all directions. Now let me share some reflections with you, and I hope they show up on my slides. Yes, potential benefits of these international proceedings. Well, first of all, I think it's fair to say that the consciousness and attention to climate change and law has never been as pronounced as now, as we speak. It is something I've worked on climate change and law for 20-something years, and it started out as this tiny niche, and now it's a real thing, right? At law schools, at courts, domestically, and now at international courts. That relationship is one of the most complex and defining legal question of our time. Now, a potential benefit, of course, would also be the clarification of what the law says on climate change. whether under Paris Agreement, under human rights law, under the law of the sea, under customary law. This is what these courts are asked to do, to clarify what the law is. Now, this clarification can turn out different ways, right? It can confirm what some states think the law is, and it rejects arguments by other states because the spectrum is so wide, which may underline some parties' positions in the international negotiations and undermine other parties' positions. There's a very interesting dynamics there. Also, I'm sure you all at some point or daily deal with international treaties, and you may know that the treaties are sometimes very hard to read, right? They're very general in their formulation and abstract and often not quite clear. But this is the nature of international negotiation, which leads to a certain level of ambiguity, which sometimes needs to be there in order for states to be able to agree on something. Now, with having these international courts now interpreting these treaties and interpreting and clarifying the law, they may cut through this ambiguity, and that may or may not be falling in good terms with some states or with others. But we still have to see what the outcome is. Now, I showed you those 4 different courts. There's no formal relationship between those courts, right? They have nothing really to do with each other. They all have their individual competence and jurisdiction, which means that every single court can come to a different result. But the questions put to those courts at the very core deal with very similar issues. Basically, what are states' obligations to reduce greenhouse gas emissions, to protect the climate system, to protect human rights, to protect the marine environment? So we can only hope that the judges in these different courts know each other and come to events like this and talk to each other and come to similar conclusions in order to create harmony and consistency in international law and not to create different standards. The advisory opinions, without doubt, will have impact. Is that something I need to? No. Will have impact. Sure. I do whatever you want me to. Yes. I'm glad it's not me who has to do it. Pertinent questions in international law that to a certain extent are also reflected in some of the domestic legal cases. Very briefly, there are, ignore the picture, it's not supposed to be here, there are certain risks connected with these international proceedings, partly because they all go in parallel. I mean, the ITLOS, the Law of the Sea Tribunal, is out, but the other 3 are still pending and they're all going, happening at the same time, which could lead, as I already said, to different standards. It all depends really to what extent these courts look at the Paris Agreement as the guiding standard on, for example, the temperature goal and emission pathways and timelines. If they adopt the same standard, it might be be possible to interpret all these different treaties in a harmonious manner. But they can also adopt different standards, and that could lead to standard shopping by states. And we still have to see that. There is somebody calling.
A mikrofont, nem az mikrofont, hanem azt a viselzapot.
Lassú addig nem rendelkezik, mindenképpen el kell érni minket.
Csak a posztbételre szeretnék.
There's also a question on behalf of proceedings before international courts relate to the climate negotiation.
We all know that climate change is a collective action problem and eventually can only be solved by cooperation of states. No single state can address the problem alone. But the question is whether these proceedings can affect positively or negatively the proceedings. Could they be constructive for multilateral solution or disruptive? That's something we'll still have to see, but there's a certain risk that once you, of course, turn to courts, and for many of the initiators behind these advisory opinions, it's very clear that this is a first step towards contentious proceedings which may follow once the courts have clarified the questions put to them. Now, my final slide, no, it's here, maybe. No. Yes. Thanks. Are the expectations? They're very general expectations. I think what we are going to see, and we already saw from the tribunal law to see, is that the Paris Agreement most likely will be used in the interpretation of other international treaties, something that we've seen, as I said already, with regard to the United Nations Conventional Law to see, and something that also has happened in many of the domestic cases. There should be, and hopefully will be, an attempt to harmonize and create coherence in international law. Again, the European Court on Human Rights in the Klima Seniorinnen case interpreted the European Convention on Human Rights also in the light of the Paris Agreement, although not very explicitly, but it used the temperature goal and the emission pathways in the interpretation of Article 8 of that convention, similarly to what ITLOS did with respect to the United Nations Conventional Law of the Sea. So I think if we see more of that from the other courts, we may see a more harmonious picture. I'm sorry. Filling that puzzle that I showed you in the very beginning. But not by direct application, other than the International Court of Justice. No other court can really directly apply the Paris Agreement, but they can apply it as a means of interpretation. The relevant elements from the agreement that we've seen so far being used in the interpretation, as I said, are the temperature goal, in particular the 1.5 degree goal, which is interesting because it also has the well below 2 degrees goal, but there seems to be a focus on 1.5 degrees, and then the corresponding emission pathways and timelines, in particular net zero emissions, global net zero emissions by 2050, but also the need for regular updates, in particular progression, that you need to do better and better and better in your climate action at the level of your best efforts or highest possible ambition. That also joined with precaution, with the need to give due consideration to future generations, as your court just found, and this is a congratulation to the Constitutional Court. I think these elements we will see both in international courts, and hopefully this will then also enhance domestic courts in their deliberations and findings. But after all, there needs to be a very careful balance, right? There needs to be a very careful balance between clarifying the law and pushing the boundaries, legal activisms. I think these courts have to thread a very thin line between these two elements. Expectations are there on both sides, but in order to keep the court's legitimacy and credibility, they will have to strike that balance. Because if these opinions take a too wide approach, that could undermine the credibility and legitimacy of these courts, and most likely would not be followed by states, right? If states consider an advisory opinion to be judicial activism and beyond what they would expect the court to say, they probably would ignore it. But if it's too narrow, if it's too restrictive, if the courts are too restrictive in their interpretation, then these advisory opinions probably won't have any practical impact, because they won't give any solution and a legal answer to these very pertinent questions on climate change. So it is not easy to be a judge these days, I guess, neither in domestic courts, domestic apex courts, nor international courts, but a lot depends on judges. That's my last word. Thank you so much.
So thank you so much. Our next speaker has lots of positions. I try to introduce him briefly. Professor Gyula Bandi is the Hungarian Ombudsman for Future Generations, head of the doctoral school at Pázmány, Péter University, Jean Monnet Chair of EU Environmental Law at Pázmány University, honorary president of the Environmental Law and Management Association, and has lots of other positions. Professor Bandi, the floor is yours.
Thank you very much. I think this introduction it does not count in my 15 minutes, because otherwise I have very small time left. But in any case, I could learn that at the end, if it is a bit longer than expected, somebody is calling from outside, just warning you, no? But that is still, it is already beginning. Okay. Thank you very much. Thank you for this introduction, and thank you for this conference. If it is not so easy to be a judge today, then it is not easy to be an ombudsman for future generations either, in the given circumstances. So I have, not only because I have 15 minutes only to go, but also because of the work. Reka told about the situation of war, and now we have already this close. Okay, let's go. First, something about the constitutional mandate. I don't want to go into the details, because many of us have already... By the way, there were so many reflections to my very small role in this whole future generation situation, that it would be even better to say that thank you for listening, and the next speaker is coming. But, and already you could hear something about the constitutional mandate they were referred to. But anyway, I would like to mention something about this. This is also the national avowal of the Hungarian fundamental law has been mentioned, but there is one very small half sentence that speaking about an alliance among Hungarians of the past, present, and future. Later, I would like to refer to the question in a word, and then it will be even shorter, to human dignity, because we are talking about human dignity as a beginning of human rights, or a basis of human rights. Then practically it's not a right. It's a kind of characteristic of the human beings, the human dignity, and human dignity is not for one person, it's for humanity. So when we are talking about past, present, and future, then this is a long line. The next is the Article P, already mentioned several times, common heritage of nation, and also the obligation of state and everyone, and to present future generations. This is the, by the way, this Article P is highlighted mostly in the Ombudsman Act as one of my basic tasks to how can I say, to help to protect it. Then there is the already mentioned right to mental and physical health, where environment is a tool, and the right to a healthy environment. And I just quote the Gabčíkovo-Nagymaros case of the International Court of Justice, saying that environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. So everything provides a very good basis of my activity. Going back for a while, as you can probably see from this message of the fundamental law, that this future generations issue is rather combined or oriented on the sustainable development, mostly about the ecological side of sustainable development, and less to absolutely not on the economic side, and less on the social side also. Just a remark. Yeah, it is a very interesting question. It has already been raised. Balázs Sanda mentioned that rights, we can speak about rights about when somebody is present, and we cannot speak about rights when somebody is expected to come somewhere in the future. So therefore, when the question is that whether we should talk about rights of future generations, then my answer is, and not only my answer, is that no, it is the question of the duties of today. Rights of future generation is otherwise a very good PhD study topic, that how to describe, but has not too much practical meaning. So some words about this. More than 12 years ago, the UN Secretary General referred to the presentation of their limits, of their interest limited to the vicarious concern of present generations. And then also there is a decision of one of the very basic environmental decisions of the Constitutional Court after the fundamental law, then entering into force of the fundamental law, when the Constitutional Court referred to the question of rights and duties, and speaking about the necessity to have legislative and institutional guarantees instead. I mentioned already human dignity, I don't want to mention again. And the last remark, general remark, is about the human right decision of the General Assembly, saying that environmental human right, or rights, because many have water rights, to water right to indigenous people rights, also some have a very important message about this. Because anyway, this is critical to enjoyment of all human rights, and this is very, very important, because it is not something which we added to the human rights, but now we have to learn that without this concept of environmental human right, the others have nothing to do. And also here I like to mention my very old-fashioned way of thinking, that what we called environmental issue and what is today climate change, it is not too far away. They are more or less the same things, because when we are talking about climate change, we mention biodiversity, we mention forest, we mention soil, we mention water. So everything is, we have to take everything as a big problem. And now, it's a mistake, I'm sorry, this is, we were requested by Marcel Szabó to make an opinion, but it was 2 years ago. It is at the end of, it's not 2025, it's 23, I made a mistake, I'm sorry. So we made this opinion to the Constitutional Court, and that's the question which I want to summarize now, that what did we say? First of all, we started our opinion about the original basic judgment of the Constitutional Court from 1994, and this is, the quotation is a bit later, about the need of institutional protection, intézményi védelem in Hungarian. So to create institutions. So that is the message, that how can you look at the environmental rights, that you have to create institutions. I mean, you is the state, of course not we have to create. And that's why procedural and institutional guarantees should be presented, and these must be implementable and clear. It was the message of the our paper. And also we referred to the fact that has already been mentioned that this Hungarian Climate Act is an extremely long paper, less than 1 page, containing several details and tasks for government. Maybe not, okay? So that in our message it was taken as and it can even be taken as a lex imperfecta, because there is nothing about implementation, nothing about requirements, nothing about tasks and duties. So it is, but the message itself, it was our opinion, the message itself that we have something like this, and a climate change act, it's positive. So we don't have to do anything else, but to keep the title and to change the content, or to add something to the content. What it was, some more or less has been the message. It was the message just yesterday. The judgment it was issued yesterday. It was the Constitutional Court. We came from the question which already mentioned by a previous speaker also about the due diligence. That of course it is not possible to say that a government is responsible, that CO2 emissions are taken by 5.6%, and no, it doesn't work like this. So it's a due diligence. You have to define obligations, and you have to take care into your of this. We are also a small country, not a small island state. Maybe a little bit bigger, but you know, I think if I remember well, help me if I'm wrong, it's it was 0.4% the Hungarian part of the whole climate. 0.1, exaggerated. So 0.1. So it's not a real big impact. And then also it has also been mentioned this public trust doctrine. That public trust means that you are again responsible. You are a fiduciary. It's again from the Constitutional Court, previous judgments related to the forest legislation, which were our initiation some years ago. So it's a fiduciary of future generations as beneficiaries, manage the natural cultural treasures, and so on and so on and so on. So this is a due diligence which we refer to. And also a very important question connected with this is that the obligation of cooperation for the climate objectives, to cooperation with the international community and also within Hungary, with the Hungarian community. Another message was in this paper is the need of long-term thinking and planning. May I use the time for an advertisement? Because just yesterday we published a general opinion about the importance of planning in environmental decision making. So I just recommend everybody to read it. In the next break I will have questions to you. How could you understand it? Okay. So, so what is the long-term thinking? That we have to provide rules and procedures, criteria and detailed rules, it is written by the planning. Who wrote this? This is the European Court of Justice, who mentioned it just some years ago. What is the essence of planning? So when we are this Hungarian Climate Act with this lengthy paper did not mention practically anything about this. Then the Hungarian Constitutional Court refers to a long-term view across government cycles, and a little bit later, long-term deliberation encompassing government cycles. This is what should be the basis of the whole. Planning cannot be very general. If in the plans you do not have the necessary criteria and detailed rules and the means of implementation and the measures addressed, then there is no use. So, and we also emphasize that the current version, which at the moment it is not, I can't say this any longer, that the current version, the previous version of the, up till now, this act was made in a way to put the burden on the future generations, saying that nothing has to be done till 2030, but afterwards. It's not only future generations, but of course children and young people. And the last point which we raised in this paper, there were several smaller items, but I do not want to. And also, I was warned that in 15 minutes the enemy is coming and calling me. It is the precautionary principle. We should not forget precautionary principle because it speaks about this scientific uncertainty and uncertainty as such. And then, in case of uncertainty, the situation is that the burden of proof is converted to the one who has the interest in it, who wants to take it and wants to use it. Then okay, then you have to prove that in our specific scientific knowledge, it does not do any harm. By the way, this is the minimum requirement when we are using human rights concept, that what is the minimum that does not make harm. And it is also, the first message is again from the Court of Justice, it's BSE case, the E is left. I made it yesterday, so sorry, again the same, not on the plane, but so the brain sponges epidemic, somebody might remember that. And the other is from the Hungarian Constitutional Court, judgments that the state must take into account the current state of science in accordance with precautionary and preventive principle, and if it is not the case, then this, from a constitutional point of view, might not be acceptable. And this was practically not really, might not be detected in this Hungarian act. So that was the summary of our opinion. That's what I wanted to mention, and many has been reflected in this judgment, and thank you very much for it, and thank you for listening. I hope I do not. There was no sign, so 50 minutes is there. Thank you very much.
Well, thank you so much for Professor Bandi for this great presentation about the Hungarian practice and the Hungarian Institution of Future Generations. And now our next speaker is Professor Katalin Súlyog. She is currently Associate Professor of International Law and Sustainability at Durham University, the United Kingdom, and if I'm right, a visiting professor at the moment at the Delta Law School, teaching environmental law. She had and has several positions, including, among others, she was a former head of secretariat at the Hungarian Ombudsman for Future Generations, and she was participated as legal advisor in the oral and written intervention submitted to the European Court of Human Rights in the Klimaszenérin and Duarte Agostinho cases. Katalin, the floor is yours.
Thank you so much. Good afternoon. I just need to find my slides. That's weird. They were here not long ago. Yeah, itt volt a feltöltöttük ide aztán.
Ezek közül lehet, hogy valamelyik esetleg, vagy itt fenn, valamelyik ezek közül. Esetleg ez.
Nézőben a...
Itt is.
Megítettük a... Ott van. Sorry for the technical problems. It seems that we are cursed today. So, I'd like to zoom out today a little bit from Hungary and give you a quick overview of how the idea of future generations is really transforming, in my view, the dynamics of climate adjudication and the reasoning of the courts and the sort of the dynamics of climate litigation. I will argue that there actually are two possible pathways for courts to enforce the idea of intergenerational equity, the idea that we owe certain obligations towards future generations. One is the pathway of recognizing it as a standalone principle, and the other one is not recognizing it as a standalone principle, nevertheless enforcing it within the ambit of other binding norms. So now we all know that intergenerational equity, the idea that we owe certain obligations towards future generations, is a very old idea. Actually, it is very deeply rooted in moral and religious teachings, and it has entered the body of international environmental law very early on with the Stockholm Declaration, where Principle 2 actually speaks about some correlative state obligations. So states are supposed to protect the Earth's resources for future generations. And later on, it has made its way into countless soft law documents, even to some binding treaties, although often mainly into preambular paragraphs. But the general consensus is that it has become a principle of international environmental law. And there are also neighboring concepts, sort of incarnations of this idea, namely the intergenerational equity principle, intergenerational solidarity, intergenerational fairness, which is becoming a sort of a buzzword in EU law right now. The EU Commission is just drafting its strategy on intergenerational fairness. And we also have this concept of intergenerational burden sharing from the Strasbourg Court, but also from some domestic courts. But if we look at the sort of the practice of international courts, we see that this principle has never been treated up until now as a justiciable principle. So international courts have never imposed any standalone binding obligations on states on the basis of this principle alone, even though the idea has been raised by litigants early on, also by the US in the 19th century, and also by Hungary, which relied on this idea, intergenerational equity, in the Gabčíkovo-Nagymaros case, and we argued that the court should expand the temporal scope of the due diligence obligations of states to prevent transboundary harm with a view to future generations. But unfortunately, these principles or these ideas have not been picked up by the courts. So altogether, in the first phase of international jurisprudence, the sort of legal value, normative value of future generations has been exhausted in putting in context the importance of the matter. So even though it has been recognized as a standalone principle, it has never been treated as a justiciable, actionable principle. We have some very influential individual opinions from international judges like Judge Veermantree or Judge Trindade, but that's all that we had so far. And now all eyes on international courts, whether they will change their course towards future generations in the pending advisory opinions. But before going to the international fora, I'd like to address how this idea has been treated by domestic courts, because and in domestic law. Domestic laws seem to take another approach. Intergenerational equity principle is rarely enshrined as a standalone principle in domestic laws, even though the idea of future generations appear in various domestic laws, but not under the heading or banner of intergenerational equity. But future generations by now are mentioned in roughly 40% of all constitutions worldwide. The ratio is even higher in Europe, where more than 50% of the EU member states do recognize future generations in their constitutions in some form. I'd like to refer to the 2024 annual report of the EU Forum of Judges for the Environment. You've already heard of this institution, FIA, because President Luc is with us, and he's the chair of this institution. It's an umbrella organization of European environmental judges, and I had the privilege of acting as their national rapporteur in drawing up this report, in which we asked the member judges of this organization to report on their domestic laws and domestic practices and case law on future generations. And so this report reveals that future generations are mentioned at various parts in national constitutions, sometimes in preamble references, but sometimes they are mentioned or they are part of explicit duties imposed on state organs like in Hungary or in Germany. Some states have standalone legislation on future generations, and many states treat the idea of future generations being qualifier of human rights obligations. Interestingly, legal systems do not provide a clear-cut definition of future generations, but again, curiously, this does not seem to be a problem for courts, so no judges reported any sort of difficulties from their respective national jurisdictions in applying this concept. So we see that even though excuse me for that. So even though intergenerational equity principle is not enshrined as a standalone principle in domestic laws, domestic courts nevertheless rely on this concept, and they read the idea of future generations into other well-established, actionable and justiciable legal norms. So in my view, this idea is very much gets enforced indirectly through other channels. Interestingly, the report also shows that courts rely on this concept even when future generations are not mentioned in their underlying constitutions. So it seems to be a very persuasive idea, irrespective of the national constitutional legal context. And I believe that this increasing judicial attention about increasing judicial awareness and interest in future generations is not a coincidence. It comes at a time when actually the harmful impacts that we would like to tackle through the future generations narrative are not in the distant future, but actually they are affecting ourselves and will affect our own older selves. So no one's talking about our grandchildren, and undoubtedly not my grandchildren, because my kids are just so very young that I cannot even fathom when I will become a grandmother. But as you can see on this chart from the IPCC reports, the question which is at stake now is the climate future that we will have to endure in our 60s or 70s. And I think that this may be a reason behind why judges and courts, irrespective of their legal systems and national jurisdictions, are very much interested and receptive to the idea of relying on future generations in order to modify the sort of the contours of state obligations. So we see from this report that in Europe, at least, judges use the concept of future generations in various types of cases, mainly in the environmental context, but not only environmental context. It is also mentioned in energy disputes or naturally in climate litigation cases. But in some states, the idea of future generations are used in cases relating to cultural heritage protection, or even in a wider context such as budgetary policy, pension reforms, or spatial planning. And again, sort of the overall message that has emerged after reviewing all the domestic case law is that the idea of future generations allow national courts to sort of take a longer-term view, take a step back, and try to break the sort of short-termist bias of the presentist short-termist bias of democratic decision-making, and the concept of future generations can serve as a counterbalance of short-term, mainly economic interest, and it allows courts to balance competing interests on a longer time scale. But how can they do that? So what are the actual legal bases that they can use to do that? And in this paper, I argue that I believe that the idea of future generations is transforming judicial reasoning, at least in four main ways, or through four main avenues. One is that future generations impacting the contours of states' human rights obligations. The second main avenue is factoring in the scope of states and corporations' due diligence obligations. We also see that classical non-discrimination standards are now applied in climate litigation cases as age-based discrimination standards, and we also see that future generations are factored into the court's assessment with respect to justiciability and standing. Now, in the interest of time, I will not bore you with all these details, but I would like to reflect some examples from the case law. So one of the, again, I believe, cross-cutting solutions emerging from the practice of domestic courts is that the idea of future generations allows courts to extend the temporal scope of human rights obligations and thereby mandating states to take protective measures even against those climate impacts or climate harms that are not yet here but are imminent in the future. Some jurisdictions use the rights of children, or some even talk about the rights of future generations, mainly in Latin America. Others use the rights of indigenous peoples to argue for climate action duties on part of states. And in Europe, we see that generally applicable human rights are sort of extended to the future, mainly the right to life, right to private life, as it was done by Dutch courts and Belgian courts that we heard in the morning. The right to healthy environment is the right, the main avenue through which the Hungarian Constitutional Court approached this question. And the German Federal Constitutional Court, as we all know in the famous Neubauer case, told that every freedom right will be put in jeopardy if present generations do not act here and now in order to prevent these future harms from happening. Another cross-cutting sort of trend in future generations litigation, so in climate cases where the plaintiffs rely on these interests and the courts are reasoning by referring to future generations, is to create sort of novel duty of care obligations where the duty bearer, the state, the lawmaker, has an obligation to care for the future. And again, we can see that this is done in many states through the public trust doctrine. In other jurisdictions, it's tackled under rights of nature doctrine or some sort of other stewardship type of obligations. And we have also some peculiar solutions from common law systems where they argue for some duty of care over minors' obligations. The same idea is now popping up in the sort of new wave of corporate climate litigation. Dutch courts found that even corporate entities have a duty to care for the future, and this duty means that they have to conduct their business in different ways than they used to. And the same idea is present in the Smith versus Fonterra case, about which Caroline Foster will shortly give you a much deeper overview. So I believe that the idea of future generations really transforms how courts are reasoning, and because of the influence of courts and judicial decisions in our legal system, I believe that on the long run, this idea may transform not only case law, but also environmental and climate governance, how these laws are made and enforced. And in this paper, co-authored together with Ole Pedersen, we argue that there are at least three main directionalities, three main ways in which the idea of future generation tries to break new ground. The first is that this idea, this concept of future generation acts as exerts a decentralizing force. It allows non-state actors such as ombudsmen or subnational entities such as communities, federal states to be part of the discourse, be plaintiffs or respondents in these cases. It's also interesting to note that future generations nevertheless do not emerge as a homogeneous global entity. Every national domestic court so far were only willing to talk about their own future generations. So they do not want to protect the future generations of other states, but they are focusing on their own future generations. The idea of intergenerational equity also exerts a diversifying force. We see new legal subjects. We are talking about new rights. Plaintiffs are using new legal strategies, new legal doctrines, and again, we see that courts are using new narratives and new obligations. And lastly, and perhaps most importantly, the concept of future generations acts as a sort of expansive force in the sense that it expands the sort of the scope of binding obligations that states have to comply with. First and foremost, it expands the temporal scope of obligations, so now states also have to care and protect the rights of future adults or future children or future individuals. but also we often see that courts are actively relying on and closely relying on soft law aspirative standards in interpreting the scope of binding obligations, and I believe that the idea of future generations is a key for them to do that. Future generations, in the second wave of climate litigation, the idea of future generations also reached international courts, most famously the European Court of Human Rights in the Klima-Sanorinen case, where the court, as you may already know, handed down a historic judgment which was more than 150 pages long, and that was the first time the Strasbourg court interpreted the scope of state obligations in the context of climate change. It found a violation of Article 8, and the cornerstone, the very first idea from which the court later on expands on its whole analysis was the idea of intergenerational burden sharing, the idea that the present generation cannot put excessive burden on future generations. Importantly, this was more than an empty rhetoric. It was more than just a symbolic tip of the hat towards future generations, because the court then later on went on and imposed some actual binding obligation on states based on this principle, namely that they have to act now. They need to take urgent action. It's not enough that they reach net zero by the mid-century, because due to laws of atmospheric physics, all these emissions are building up in the atmosphere. So if we want to save our older selves from the hothouse Earth scenario, then early action must be taken here and now. And again, the court utilized the idea of future generations in order to reach this conclusion in a legitimate way. Now, we've heard so much already about the pending international advisory opinion, so I will not dwell on this any further, just flag that this is a space to watch. So in all these pending 3 out of the 4 international advisory opinion proceedings concerning climate change deal again or center on future generations. Really, we see that the idea of future generations is a key theme in all of these questions before the International Court of Justice, the Inter-American Court of Human Rights, and the African Court of Human and People's Rights. So, as I flagged in the opening slide, I think that there are 2 main ways or 2 main possible judicial pathways of enforcing intergenerational equity. It is either recognized as a standalone principle, or it can also come through the back door, if you like. But I don't want to make any sort of guesses about or predictions of how international courts will deal with the concept of future generations. My claim is only that the recognition, both on the international and on the domestic level as well, are ripe enough for courts to enforce this principle under its own name, and we should closely watch how this idea appears in the upcoming advisory opinions, because I agree with everyone before me who said that this will really shape how domestic courts can approach these issues later on. So thank you for your attention.
Thank you for the great presentation and the perfect timing today. And our next speaker is Professor Tamás Ádány from the Pázmány Péter Catholic University. Professor Ádány is head of department and professor of international law here. And he has an excellent job within the talent program of Pázmány University, including moot court competitions and other student results. And one thing I would like to mention, one of his last publications deal with the relationship between sustainable development goals and the Laudato Si encyclical. Tamás, the floor is yours.
Azért mondom, megoldom. Thank you so much for this very kind introduction, and thank you for the possibility to be here with you today. I have to tell you, you are an intimidating crowd, looking from up here. The room is full of judges, people well trained in international law, and there are activists who are not necessarily lawyers. So there are many kinds of people from many walks of life. And we have heard, just in this panel, 3 very good presentations on how to litigate various issues of climate change. And what I intend to do right now is explaining why everybody speaking before me was so enthusiastic about results which are not necessarily obvious for the activists. We want to have something more. There is a climate anxiety in many of us. The planet is dying, we are going to die. So the obvious connection to human rights law should not be human dignity, should not be human future generations. It should be about our right to life. And why I cannot go to a court, and why are these judges are so hard-nagged that they are not listening to these arguments. Now, this is the research question I would like to address now. And maybe I can tuck some chords in between, so everybody's going to hate the presentation in 5 minutes. In order to address these issues, I have to take a step back and make a confession. I'm a generalist in public international law, a jack of all trades, basically. I'm not coming from international environmental law. I'm fond of it very much, as you are going to see, but that's not my direct field. So for me, the fascinating thing, intellectually speaking, in the Paris Agreement was how on earth it works. How on earth it is going to work? Where is the binding force behind the Paris Agreement? What is the treaty obligation? Can I take it to court? Can I base a claim on this? And what exactly is the obligation, strictly speaking, in the Paris Agreement? And basically the obligation is, as we all know, is to make nationally determined contributions. Okay, but what are these? Because these are going to tell us what the states are actually going to do to save us and the future generations. So how can I take them to court? And what court? In order to make any successful position in a litigation, I think we need 3 basic elements. We need a court. We need some substantive foundations for our claim. I have to have solid legal foundations for my claim. And also I have to have locus standi. I have to have the right to plead in front of the court. It's not necessarily obvious that it leads us the plethora of courts that Professor Voigt and Suyok have so eloquently listed in details. I'm not going to go through all these courts again. I'm going to focus on the actual treaty obligations. So let's start on focusing on the substantive law part, which from the Paris Agreement, everybody knows it well, so I'm going to be very brief on this. It comes from Article 3. All parties are to undertake and communicate ambitious efforts. It's strange. It's not a hard law obligation to promise to communicate efforts. That's the obligation, and to make efforts and to make them public. That's the actual obligation. And of course, we know the contents for these nationally determined contributions, so how the states are going to achieve the climate goals. Now, if I want to translate it into the language of any international judge, particularly those sitting at the International Court of Justice in The Hague, I have to find something what the court can apply. And the court applies, according to this famous list from Article 38, 3 things that we, out of necessity, identify as sources of international law: treaties, customary law, and generally recognized principles of civilized nations. This last one is not going to be important for us, so we'll focus on treaties and customary law. When there is a kind of doubt, we have 2 subsidiary means for the determination of the law. basically judicial practice. That's why these upcoming decisions are so important, and maybe scholarly teachings. If we browse through this, we find several extra sources that are actually suitable to win a case in front of an international court. Most importantly, for my presentation, there are something called unilateral acts. There is a bunch of case law from 100 years old to just a few years old, from the International Court of Justice, Permanent Court of International Justice, which set out a system that basically if a state makes a declaration, this declaration may become binding on the state. So far it is obvious. And now comes the hard part. What is the content of such declarations? Who can make such a declaration on behalf of the state? And customary international law was relatively clear on this, but in 2006, if my memory serves well, the International Law Commission from the United Nations issued a set of guidelines on how to identify unilateral acts of states. Now, my question is, can we apply this to the nationally determined contributions? The obvious answer is yes, of course, these are unilateral declarations made by states, so they should be sources of law under these guidelines. I'd say possibly yes, but there are some problems lying in this general regulation. It's a long test, so let me highlight it for you. Look at the wording. We are speaking about may have effect, not can or does have or shall have. It's may have. It definitely happens on a case-by-case basis. To serve time, I'm not going to give you all the arguments, just trust my educated guess on that fact that the context of the nationally determined contributions make them extremely suitable to become legally binding on states. So that's not where the problem is. A potential problem, and I apologize for the American colleagues here, but I'm going to focus on Europe for a while because for me it's going to be a bit problematic. A unilateral declaration under international law must be made by an authority, a state authority. If you know, the list follows with heads of states, heads of governments, the big three. The parliament is not even mentioned in this list. Obviously, I think it's an omission, it's a stupid omission, but acts of the parliament are clearly unilateral acts of a state. The current Hungarian unilateral act is, of course, the EU NDC. And the EU NDC is defined by not really a legal act. Of course, we have the legal foundations in the Treaty on the Functioning of the European Union, Article 190, whatever, 1, 2, 3, around that place, which entitles the Council to make communications, to make decisions in environmental law. But this is not, well, if it's the Council, it's the European Council, it is by an authority vested duly from the states. These are representatives of government. So again, this is not a major problem. As for the style, it's not a strong point, but it still holds. So it's something like in a structure, I'm using duct tape to keep everything together, but at this stage, it still holds. The wording must be done in a clear and specific terminology. Now, if you read these nationally determined contributions, I think that's where the problem starts. These are strong promises on making serious considerations to identify future efforts that we may attempt. If I make a promise like that to my 8-year-old son, he's going to throw a tantrum because he knows he's never going to get what he asked for. A major problem, and it's not, I think it's often overlooked. Unilateral acts must be interpreted in a restrictive manner. That in itself makes litigating these, the justiciability of these contributions really an uphill battle. Silver lining, They cannot be revoked arbitrarily, and that's the point where I would connect to the recent decision of the Hungarian Constitutional Court. It's a clear legal foundation for the non-regression principle. It's just strengthening that, so there's kind of harmony, not contradiction in international law. About international courts, so many have been identified, so many will be identified, so I am not going to give you too many details, just a few ideas. We may try litigating in front of national authorities, like Monsieur Carême tried to do at the Conseil d'État in France, but it's not necessarily going to work. Let's see what we need. We have seen, we have the courts, we have the substantive law, so we need the victim status, the locus standi, the right to be there. And of course, at the European Court of Human Rights, it comes from the Klima Seniorinen case, argued by a set of brilliant lawyers in front of the court, and for those present in the room, I'm making a compliment publicly. I think it was a very good call not to pose the claim on Article 2. So going for Article 6 and Article 8 has something to do with the fact that from the three cases decided together, Klima Seniorinen win. The other two base their claim on a perceived violation of Article 2, the right to life. And as we see, the Klima Seniorinen case raises a very high standard for the victim status, for the locus standi. It is visible that judges were a little bit afraid of the frightening perspective of this global climate anxiety, and that they will be overwhelmed with claims, with applications. So the standard is high, and the court will examine elements from this list just to check whether I am in a position to claim that one of my rights has been allegedly infringed by a state. And that's just the entry to the examination on the merits. And how hard it is brilliantly shown by Duarte Agostinho et al., the Portuguese kids who filed a complaint against the majority of the Council of Europe member states, and their claim was found inadmissible because there were uncertainties about their individual situations. And I know that tomorrow morning there will be a much more detailed presentation from a much better source than myself about the Grand Sint litigation of the Conseil d'État and that of the European Court of Human Rights. I will just point out a few strange elements that sound strange for the first reading. Spoiler alert. The mayor of the small French suburban settlement was found not in a victim position, either as a mayor, as a politician, as a representative of the community, or in his personal capacity. Now, it's a small suburban village on the French northern coastline, 2 meters above sea level, so they are going to be hit by the catastrophic impact of climate change by 2050, and that was acknowledged by the Conseil d'État. Also, it was acknowledged that there is a need to act without delay. However, Monsieur Carême is not entitled to pose this claim. Now, why not? I'm going to be joking, of course, but it's all the fault of the European Union and politics. Monsieur Carême was elected to become a member of the European Parliament. And you know what he did? He moved to Brussels. And now he lives in Brussels, and he doesn't live in Grand Sint. So he has no locus standi in front of the court because he lost his meaningful connection to the community. And that's it. That was the key element. Of course, the Conseil d'État found something similar, that he did not have an interest in the proceedings and so on. But for the European Court of Human Rights, moving to Brussels was the arch sin, for no absolution was given. And of course, I can cut short my presentation because I'm very grateful for the great presentations on the advisory opinions. I would just add a final closing remark, which is not going to be very hopeful. My academic background is more related to international criminal law, and this is a very familiar number to me, 130. That's approximately the number of the state parties to the Rome Statute of the International Criminal Court. It sounds like the majority of states. Originally, there was 120 states sponsoring the proposal of Vaunatu, and 12 extra joined, Hungary included, a few days later. So now we have really an outstanding number, as Christina have pointed it out. Among these sponsors, there is one from the P5, the United Kingdom only. So we miss the United States, China, France, and Russia, which is more promising that from the G7, from the developed countries, only 2 are missing. So we are starting to go beyond the north-south divide, and that's the good sign here. And having read all those interventions and considering state sovereignty as the cornerstone of international operations, and the legal nature of unilateral, nationally determined contributions understood as unilateral declarations of states, I do not have high hopes that the coming advisory opinion is going to be too wide, as citing Christina. I think there is a chance that it's going to be too narrow and leaves the actual obligations up to the competence of states. Regardless of 2/3 majority of the states seemingly wishing for a clarification, I'm afraid it's not going to be enough. Thank you so much for your kind attention, and sorry for ending a disappointing note.
Ladies and gentlemen, 2 online presentations coming. The first one from Christina Binder, who is a professor of international law at Bundeswehr University of Munich, and then Professor Caroline Foster, who is a professor of environmental law at the University of Auckland, New Zealand. And after then, there will be no so we try to shorten the intermission between the presentations and the 10-minute coffee break. And if you'd like to take a coffee or tea or water, just serve yourself in front of the room. So at the very end of the conference, we will be mostly in time. Thank you so much.
To this conference, dear Master. I'm really sad that I cannot join you in person today due to the seminars in Vienna. Still, many thanks for the opportunity to deliver this virtual presentation. To explore the contribution of the local level to realize international human rights obligations in the context of climate change seems most topical. This in particular, given the complexity of the climate crisis and the need for all actors, including the subnational, local level, and in particular cities, to deal with it. In this brief presentation, I will unfold my argument as follows. I will first explore the role of the local level to human rights implementation and the fight against climate change on a more general level. To then turn to the example of the European Urban Charter III, whose second revision was adopted by the Congress of Local and Regional Authorities of the Council of Europe in October 2023, and which incorporates, I think, most promising approaches to fight climate change. Indeed, I had the honor to accompany the revision of the Charter as an expert. So, let me start with more general considerations. A focus on the subnational level in relation to climate change corresponds to the growing importance of cities in human rights protection and implementation more generally. For instance, several soft law instruments refer to the role of local and regional authorities in human rights protection. Recommendation 280 of 2010 of the Congress of Local and Regional Authorities insists that, I cite, local and regional authorities are not only agents of the central government, they secure human rights at the same time as they fulfill local self-government. Also, the Advisory Committee of the Human Rights Council noted that whilst, again I cite, it is the central government which has the primary responsibility for the promotion and protection of human rights, local government has a complementary role to play. An increasing role of local authorities and cities should indeed contribute to the most comprehensive anchoring of human rights at both the national and especially the subnational levels. This holds true even more since human rights are not a purely legal project, but also based on political, sociological, anthropological, and other factors, which makes their embedding in society as a whole all the more necessary. The latter may probably best be achieved when next to organized civil society, national human rights and ombudsman institutions, as well as the media, also municipalities and cities are involved in the realization and more specifically the implementation of human rights. Since the local level is generally most directly in touch with the population, this ideally contributes to the development of a human rights culture. There is thus much to say in favor of the role of cities from a human rights perspective. So, the local level turns increasingly important for the implementation of human rights, as well as in countering climate change. Its potential is acknowledged likewise in legal scholarship. For instance, Frédéric Mécry affirms, the embrace by many local actors of their human rights responsibilities remains a productive moment in the history of human rights. He continues, but I don't have the time to give the whole citation. Also, when addressing the climate crisis, the relevance of the subnational level has been explicitly recognized. For example, in the context of climate action, the local level's potential in fostering popular backing and increasing legitimacy has been emphasized. Local authorities have also been praised for their practical effectiveness. Cities therewith become important human rights actors, including in the context of climate change. They complement the national level in relevant areas, especially as regards human rights implementation and the fight against the climate crisis. Such increasing role of local governments in international law may also be argued on the basis of the principles of subsidiarity and participation. These principles additionally emphasize the important role of local actors in the implementation of human rights, including obligations in face of the climate crisis. Especially the subsidiarity principle seems of key relevance. Thus, as affirmed by Pavoni in the context of sustainable development, I cite, local authorities constitute the level of government closest to and most immediately representative of the citizens. They are therefore best placed to assess the needs and the interests of citizens and are, to a greater or lesser degree, directly accountable to them in case of regulatory failures. Put differently, in line with the subsidiarity principle, the local level, as the one closest to citizens, is frequently best placed to identify the most adequate policies for upholding human rights, as well as in relation to climate change. In the context of the climate crisis, this was also put in terms of appropriateness. According to Uman, One of the key challenges in combating climate change is the complexity of its causes and the vast array of potential ways to address them. A strong role for subnational authorities allows for a focus on those measures that form an optimal fit with the people, place, and purpose. In short, the subnational level has a key role to play in both human rights and climate change. This is most evident in the context of climate-related policies in the fields of mitigation, adaptation, as well as participation. Which brings me to my next part on the European Urban Charter of 2023, which I think is a perfect showcase of how the local level may contribute to deal with climate change in human rights respectful way. So let me first start with some generalities on the European Urban Charter 3. What can the local level, cities and local communities add to human rights in the face of the climate crisis? The European Urban Charter 3 may indeed serve as model here. As stated, the Charter was adopted in October 2023 by the Congress of Local and Regional Authorities, a second revision of the first European Urban Charter of 1992. The revision was considered necessary against a backdrop of changes in European urban life, being inter alia the climate crisis, next to COVID-19, the Ukraine war, and the development of digitalization, smart cities. This is alluded to in the Charter's telling name, which reads in full, the European Urban Charter 3, Urban Living in the Era of Transformations, and is likewise reflected in the comprehensive approach to climate change throughout the Charter. So, and this brings me to my next part, how to best respond to the climate crisis plays a prominent role in the European Urban Charter, as regards mitigation and adaptation measures, as well as in terms of participation and procedural tools. Among the Charter's 6 sections, the entire Section 3, Sustainable Development, Protection of Environment and Climate Change, features measures to address, amongst others, the climate crisis. It contains a total of 6 principles, all of which may be, more or less directly, linked to climate action. Climate change is also mainstreamed as cross-cutting theme and reflected in several principles sections throughout the Charter. The Charter therewith provides important guidance for climate change-related policies at the local level. More generally, local authorities are directed to adopt multidimensional policies and streamline environmental protection and the fight against climate change into urban policies, mitigate the consequences, and reduce the impact of climate change. That was a citation. In doing so, urban residents' participation in environmental decision-making is considered key. For example, the Charter directs local authorities to, again I cite, engage in awareness raising and information campaigns, as well as a general education of urban residents in environmental affairs. Also, possible mitigation measures to prevent climate change are referred to in the Charter. In terms of natural wealth and resources, inter alia, the promotion of renewable energy and energy efficiency, as well as the furtherance of green technologies emphasized. Likewise, the promotion of a circular economy is mentioned in the Charter, and this should contribute to this objective by furthering the production of goods and services in a sustainable way. In Section 2, Social Rights, Economic and Cultural Development, one principle more generally mentions the necessary support of, again as said, balanced and forward-looking economic development, taking into account environmental protection. The objective of mitigation is also acknowledged when it comes to mobility. The aspired sustainable mobility, the promotion and improvement of the attractiveness of climate-friendly means of mobility, including affordable and adequate public transportation, the reduction of private cars, and the city of short ways, where access to various urban services is situated in immediate vicinity, contributes to counteracting climate change. Moreover, the need of adaptation is duly acknowledged in the Charter. In relation to food security, resilient, cost-efficient urban agri-food systems are considered with specific mention of the necessary adaptation to climate change. Additionally, in the section Security and Crime Prevention, the principle resilience foresees the necessary provision of effective and adequate responses to crises and emergencies as natural disasters, for instance, heats, droughts, earthquakes, or floods, as may likewise be caused by climate change. In sum, numerous dimensions of relevance in the fight against climate change are addressed in the European Urban Charter. Local authorities are requested to comprehensively respond to the challenges of the climate crisis. The European Urban Charter 3 therewith contains a comprehensive catalogue of what could be done to deal with climate change, from participation in decision-making to mitigation and adaptation policies. Therewith, the Charter is an important tool to guide climate-relevant action of local authorities. Its importance is supported by the concise, convention-style way in which it is drafted, the division in actionable principles, and a more extensive narrative explanatory memorandum should facilitate the Charter's operationalization. Let me now conclude. Local authorities and cities may play an important role in states' endeavor to live up to the challenges caused by the climate crisis. Therewith, the local level turns to be an important actor in the realization of states' human rights obligations in relation to climate change. Local authorities may most effectively complement the national level in the design and implementation of climate change-related policies in a human rights respectful way. This turns most evident by taking the example of the European Urban Charter, which guides the action of local authorities, including in relation to climate change. Accordingly, the European Urban Charter is a great example of how to operationalize the contribution of the local level to international human rights obligations to address climate change. Many thanks for your attention. I wish you a wonderful continuation of the conference. Thank you so much.
Greetings everyone from New Zealand, and congratulations on this excellent conference on constitutional instruments for climate protection. I'll be speaking to you today about climate litigation in New Zealand, and especially Mr. Smith's two cases. To give some background, New Zealand's primary response to climate change operates through the Emissions Trading Scheme, created under the Climate Change Response Act of 2002. In 2019, the Act was Greetings everyone from New Zealand. To give some background, New Zealand's primary response to climate change operates through the Emissions Trading Scheme, created under the Climate Change Response Act of 2002. In 2019, the Act was amended to introduce a net zero target by 2050, excluding biogenic methane, a climate change commission, and 5 yearly emissions budgets and adaptation plans. New Zealand continues to rely heavily on this polluter pays model through the emissions trading scheme. We have a climate risk disclosure regime, but no statutory corporate due diligence obligations. Against this regulatory backdrop, the Smith cases test the boundaries of New Zealand's legal response to climate change through the courts. Both cases were brought by Michael Smith, an elder of Ngapuhi and Ngāti Kahu, who's been a prominent advocate on climate issues within the Iwi Chairs Forum, a grouping of tribal leaders. He filed one case against a group of major emitting corporations and another against the Crown. His claims focus on tort-based responsibility for climate harm and the Crown's obligations under the Treaty of Waitangi and the New Zealand Bill of Rights Act. These two cases make a nice contrast for this conference to consider. One is a private law case and the other a constitutional law case. The first case, Smith and Fonterra, was filed in 2019 and marked an unprecedented attempt to hold major New Zealand companies directly accountable for their emissions. The case was brought against 7 large emitters, who Smith claimed were collectively responsible for over a third of the country's reported greenhouse gas emissions between 2020 and 2021. They included major dairy, energy, and steel companies. He argued that their ongoing contributions to climate change would cause serious harm that he, his whānau, or extended family, and future descendants would be left to bear. Smith advanced 3 causes of action in public nuisance, negligence, and a novel tort described as damage to the climate system. Across all 3 claims, he sought injunctive relief requiring each company to progressively reduce its net emissions over a 25-year period under court supervision. Alternatively, he asked the court to order an immediate cessation of all net emissions. In response, the defendants filed an interlocutory application to strike out the proceedings. The High Court struck out the negligence and public nuisance claims, but declined to strike out the novel tort of harm to the climate system. The Court of Appeals struck out all 3 of Smith's claims, finding that allowing them to proceed would involve a major departure from settled principles of tort law and risk subverting doctrinal coherence. It emphasised that tort law is built on a relational framework, typically involving a clearly defined wrongdoer and victim. But in this case, both categories were extremely broad. The court also noted the ineffectiveness of traditional tort remedies like damages for this kind of systemic harm, and expressed concern over the injunctive relief sought, which would be complex to supervise and enforce. The court concluded that climate change requires a sophisticated national regulatory response aligned with international coordination, and that courts should support that regime, not develop a parallel common law system. In 2024, the Supreme Court overturned the Court of Appeals decision and reinstated all 3 of Mr. Smith's tort claims: public nuisance, negligence, and a proposed novel tort for damage to the climate system. The Supreme Court considered that where a claim raises seriously arguable non-trivial harm, it should generally proceed to trial for full evaluation, even if novel or complex, and should only be dismissed early if it's clearly bound to fail. The first issue the court addressed in its strikeout analysis was whether New Zealand's statutory climate change regime precluded common law tort claims. The court found that the Climate Change Response Act did not exclude tort law, either expressly or by necessary implication. The court then turned to the public nuisance claim, finding that the interests Smith relied on, such as public health, safety, comfort, convenience, and peace, could plausibly support such a claim, and that his pleading warranted further consideration at trial. It left open the more novel claim that people have a public right to a safe and habitable climate. On the issue of standing, the court held that Smith's alleged harms could arguably exceed those of the general public. It also recognised that tikanga Māori customary law and practice, may be relevant in assessing whether that threshold is met. On causation, the court accepted the argument that a defendant need not be the sole or direct cause of harm in complex environmental cases. It drew an analogy with water pollution cases, indicating that a defendant's material contribution to a harmful state of affairs could be sufficient. These questions were best to be resolved at trial. The court also clarified that independent illegality is not required for a nuisance claim. It is enough that the defendant's conduct caused harm, even if the conduct itself was not unlawful under statute. As for the negligence and novel tort claims, the court declined to strike them out. It reasoned that since they arose from the same facts as the public nuisance claim, proceeding to trial on all three claims would not impose an undue burden. This judgment has been a turning point for climate litigation in New Zealand. While it certainly doesn't confirm any liability, it affirms the judiciary's willingness to consider the possibility of common law development in response to climate harms. As the court itself put it, the principles governing public nuisance ought not to stand still in the face of massive environmental challenges. In recent developments on this case, earlier this year, Fonterra brought a joinder application seeking to require that all domestic and international polluters be included in the case. The High Court declined, finding that doing so would add undue delay and complexity and would significantly compromise Mr. Smith's right of access to justice. Further, a members' bill entitled the Climate Change Restriction on Civil Proceedings Bill was lodged for inclusion in the parliamentary ballot in March of this year, aiming to bar all tort-based claims related to the effects of climate change. If this bill is balloted in, and if it is passed into law, the law would apply both retrospectively and prospectively, effectively overturning the Supreme Court's decision in Smith and Fonterra. The stated purpose is to preserve legal certainty, protect the integrity of the emissions trading scheme, and prevent fragmented tort litigation from interfering with coordinated national climate policy. As to the second case, this has been brought against the Crown rather than private emitters, and focuses on the government's overall legislative and policy response to climate change. This case has been progressed more slowly. Smith has alleged 5 distinct causes of action. First, the right to life. Smith claims the Crown has failed to protect the lives of current and future generations from the serious and foreseeable risks of climate change. Second, the right to culture. Smith alleges that climate impacts, including sea level rise, biodiversity loss, and extreme weather, threaten his ability, and that of his iwi, to engage in Māori cultural practices tied to the natural environment. Third, a breach of Article 2 of the Treaty of Waitangi. Smith argues that the Crown's climate inaction has undermined Māori self-determination, or tino rangatiratanga, over taonga, including coastal land and natural resources, as guaranteed in the Treaty of Waitangi. Fourth, breach of fiduciary duty. Smith argues that the Crown has a fiduciary obligation rooted in the Treaty of Waitangi and tikanga Māori to act in the best interests of Māori, particularly in relation to climate protection. This includes an obligation to safeguard Māori environmental and cultural rights from foreseeable harm. And finally, a novel common law Crown duty. Smith asks the courts to recognise a common law duty because the Treaty of Waitangi, tikanga, and international law. The High Court struck out all 5 claims, finding them untenable. On appeal, the Court of Appeal upheld most of that decision, but took a more cautious approach. It allowed a narrow path forward for potential New Zealand Bill of Rights Act claims, holding it was not clearly untenable that the Crown's response to climate change might breach the right to life or right to culture, particularly in relation to specific decisions. However, it struck out claims challenging the adequacy of the Crown's overall legislative framework, such as the Climate Change Response Act, as involving policy choices reserved to Parliament. The Court also fully struck out the Treaty of Waitangi, fiduciary duty, and novel common law duty claims, finding them inconsistent with constitutional arrangements and or beyond the current scope of recognised legal duties. An appeal is expected. And for completeness, a very brief comment on a few other climate litigation cases in New Zealand. In the first of these cases, students took proceedings seeking judicial review of the granting of petroleum exploration permits, and the question was whether the government was required to consider the effects on greenhouse gas emissions when granting the permits. The High Court and Court of Appeal rejected the students' case. They found that climate change was not a mandatory consideration and that Treaty of Waitangi principles had been adequately considered at the local level. The Supreme Court has given leave to appeal. In the second case, Lawyers for Climate Action New Zealand, or LCANSI, argued that the Climate Change Commission's advice to the government in respect of setting New Zealand's NDC under the Paris Agreement did not provide a valid basis for assessing whether the NDC was consistent with the Paris Agreement's 1.5 degree temperature target and was not consistent with the requirements of the Climate Change Response Act 2002. The courts found that climate change was not a mandatory consideration under the Act, that the decision was not unreasonable, and that Treaty of Waitangi principles were adequately considered at a local level. However, the Supreme Court has given leave to appeal. Let's take a look at the major gas users case. Oh, small correction, apologies. In Lawyers for Climate Action New Zealand and the Climate Change Commission, the Court of Appeal rejected the arguments, finding the legislative requirement to contribute to global greenhouse gas reduction efforts was aspirational and not binding. The Supreme Court will consider the matter. Turning to major gas users, the major gas users group unsuccessfully argued before the High Court that the New Zealand Commerce Commission, which is responsible for administering New Zealand's competition law, had erred in its decisions about permitted pricing by gas pipeline operators, because the Commerce Commission had applied an accelerated depreciation approach in regard to the useful lives of gas pipelines in light of New Zealand's signalled fossil fuel phase-out. no appeal has been launched in that case. In Alkansi and the Minister of Climate Change, Alkansi challenged government decision-making relating to unit and price control settings in the operation of New Zealand's ETS scheme successfully. And finally, a High Court decision is pending in the Better NZ Trust case on whether the government's response to New Zealand's clean car standard are consistent with the New Zealand Emissions Reduction Plan and the statutory requirement that they're able to increase supply of emission and zero emission vehicles. So as you can see, New Zealand's constitutional system and its various instruments are all being actively tested in relation to climate protection from a diverse range of angles. All the best for the remainder of the conference, and it was lovely to be able to join you virtually.
Continue with the roundtable panel, our last panel.
Mindegyik Európai Uniós. Ez mindig be van kapcsolva. Azt mondom,
A közönségnek részéről is elbeszélgetünk.
Kajakóma után, utolsó szünet után.
Mai utolsó panelbeszélgetésünk következik, amely egy kerekasztal.
Ladies and gentlemen, our last panel discussion is coming up with the environmental NGOs having the most important role in Hungary. I will not introduce anyone up front, because the first round of this roundtable will be that everyone will introduce themselves and say a few words about their organization. I will be the moderator of this panel. I work as a chief counselor at the Constitutional Court, and I would say that please introduce yourself in the order of your seats. So say a few words about yourselves and your organization. I would like to warmly welcome everyone. My name is Ágos Éker. I'm the president of the National Society of Conservationists. Friends of the Earth. We are a member of the Friends of the Earth network. That's the green circle in our logo. I think that this just one sentence that the Hungarian conservationists, we think that this decision of the Constitutional Court is a milestone decision that will be referred to in many decades, and I hope that by that time everybody will be so environmentally aware that there will not many such decisions will be needed. So just a few words about our organization. I think our society is a platform for cooperation. We have more than 100 member organizations, and we try to reinforce cooperation between these member societies. We have an institutional network focused on sustainability, and our professional field is very comprehensive and extensive. And just to say a few words in climate-specific topics, or what we were focusing on 15 years ago. We had a huge campaign, and the goal of that was that Hungary should adopt a climate law. And I think if that act would have been adopted, then we could now, today, check all the items on the list on our to-do list. And together with the Development Council, we were working on this submission. And actually, we got the support of all kinds of members of parliament from all parties. So all the political parties agreed, or had agreed back then, that we needed a law like that. However, there were other external lobby parties that prevented this from coming into existence. Thank you. For the sake of our international guests, I would like to clarify that the Constitutional Court made a decision on the Hungarian Climate Act. And what Ákos Éger mentioned was that was a professional proposal 15 years ago. However, that failed, unfortunately. And then the parliament adopted a law a few years later that was back then half a page long. So that was closer to nothing than something. So I would say that that was a soft law. We have a soft law declaration in Hungary rather than an act. I would warmly welcome all the attendees. My name is Gergő Halmos. I'm on behalf of BirdLife Hungary, and I am not an expert in the legal field. I'm here as a biologist, and basically my field of expertise is nature conservation. In the past 15 years, I have come across with the items and topics of the Constitutional Court. But back to our organization, in English, this is our English name. However, we do have a very long name in English. Therefore, we decided to go for a shorter name. We are actually the Hungarian representatives of BirdLife global or worldwide. Therefore, we named ourselves like BirdLife Hungary. And our organization actually, on my jacket, there was a medallion of a 50. Actually, we had the 50th anniversary of our organization, which was founded in the 1970s. And it was one of the rare organizations of its kind at that time. And we are working on the basis of membership. We have about 10,000 members. And these people are grouped in local organizations, and we have voluntary people, volunteers. I don't want to go into the details too much, but our number one focus is actual practical nature conservation and awareness raising, and also the species preservation programs. We have different types of birds that we try to maintain the species, and making a connection to climate protection now. We do not have direct climate protection programs. We are just connected or interconnected to the climate protection issue with the preservation activities that we pursue and the restoration of the living spaces and the fauna of certain animals, the habitat of certain birds, and certain elements are very closely related, obviously, to climate protection. And I would give the floor to the other member. My name is Csaba Kis. I am a lawyer by background, and I work as an attorney, but I'm the director of this organization. And our organization provides legal services for 30 years to NGOs and to private individuals for the sake of the private sector, never on the side of the state or the public administration. I would really thank all those present here and for your perseverance. And I think it will be worth listening to the opinions of the civil organizations to this decision that was adopted by the Constitutional Court. And compared to Ákos Éger's comments, this is really a milestone or a game-changer decision that was reached by the Constitutional Court that was mentioned earlier today. And as far as climate issues are concerned, our organization are related to this topic, that we work with 4 lawyers, and one of them is here sitting in the audience. That person is an energy law expert at the same time, and our palm is very itchy to be able to initiate and file for a climate-related litigation, and we will wait until the 30th of June 2026, and then we will start our activities, litigative activities, and hopefully we will have a different picture by then in this country. Thank you for your attention. My name is Csaba Lajos. I'm an architect by profession, and I am the chairman of the Climate Alliance Hungary. And if we look at the other organizations that I'm also affiliated with, I would like to mention Reflex Environmental Protection Organization, which was founded in 1987. And as Gergely mentioned, they celebrated their 50th anniversary. And we are one of the first NGOs that was founded after the political or regime change in the 1990s. I come from Győr, which is northwest Hungary, located in northwest Hungary. And I would also like to mention another organization where we work as volunteer, that's Green Civilian Cooperation, which brings together NGO organizations, and we have been having mutual common sessions since the 1980s. And if we would like to put ourselves on a European map, then we are part of the Climate Alliance network, and we have settlements and municipalities working together as many as 1,800 Europe-wise. In Hungary, we have 27 settlements involved and other NGOs, and we have our partners, the educational institutions. We work together with Hungarian associations, and we do, for 1.5 years, we have been involved in the European Climate Pact, We would try to put the commitments to a local level, and we have had a very efficient community involving teachers or the representatives of some economic operators or the representatives of municipalities who are working as volunteers, and they think it's very important for local communities to understand and to get to know the opportunities that can provide an answer to the climate challenges. I warmly welcome dear audience. My name is János Pál. I'm the director of Greenpeace Hungary, and I thought I would not talk about the organization itself, but our mindset. The mission of Greenpeace is to address biodiversity and other crisis areas, as opposed to other areas. We rather focus on the community and try to understand the mindset and thinking of various societal groups. I can see on your face that I'm perhaps not talking perfectly in the microphone. So to take this on from here, there are 3 preconditions for social change. You have to detect the problem on a mass basis. People, majority of people must feel and see that a given problem is a critical problem ahead of us or challenge ahead of us. The second is that you have to have a legal solution on the basis of which you can build up a solution. And then the third item is a political willingness to take this up or take this on. And I would like to thank all the people and parties involved in this work, and I really welcome this wise decision that was adopted by the Constitutional Court, and this is a great help for Greenpeace.
Én is szeretettel köszöntök mindenkit, Sipos Katalin vagyok, és én itt a mögöttünk lévő logók közül a legfeltűnőbb és legkedvesebb logóhoz tartozom, a pandához. Én vagyok a WWF Magyarországnak a vezetője. Én biológus vagyok egyébként, úgyhogy a nem jogász résztvevőknek a körét bővítem, és hogy miért ülünk itt, meg miért ül itt egyáltalán természetvédelmi szervezet, azt szerintem itt ebben a körben nem nagyon kell magyarázni. Ugyan a belépési pontunk a természet, de a természetvédelem nagyon régóta nem csak konkrét fajok, meg élőhelyek védelméről szól, hanem rendszer szintű problémák kezeléséről. Úgyhogy mi is a munkánk nagy részét az fenntartható vízgazdálkodás, fenntartható erdőgazdálkodás, a mezőgazdaságnak az átalakítása, szóval ezek az egyszerűnek éppen nem nevezhető rendszer szintű problémák állnak a munkánknak a középpontjába. És hát a kulcs szó, ami miatt én személy szerint nagyon örülök ennek az alkotmánybírósági anyagnak, az a mi oldalunkról a legfontosabb kulcs szó, azt hiszem az adaptáció, meg a klímaváltozásra szembeni reziliencia, úgyhogy erről majd nagy örömmel fogok mondani néhány szót.
Köszönjük szépen. A második kört már nem beülés sorrendjében, hanem tetszés szerinti sorrendben dobnám fel kérdésként, és előzetesen mi nagyjából egyeztettünk arról, hogy milyen témakörök fognak itt szóba kerülni, tehát senkit nem fog meglepetésként érni, hogy mi lesz a második spontán módon feltett kérdésem. Ez arra vonatkozik, hogy önök ti a saját területeteken kifejezetten most a klímát, tehát nem általában a környezet és természetvédelmére, hanem kifejezetten a klímával, a klímaváltozással, a klímaválsággal összefüggésben, hogyha egy nagy problémát kellene említeni, ami nem a klímatörvény és nem a pénz, akkor mit említenétek meg? Tehát mi az, ami szerintetek ma a legnagyobb valódi problémát okozza? Itt nem feltétlenül jogszabályokra gondolok, akár emberi tevékenységre, tényleges környezetállapotára, hatásokra, jövőre, tehát gyakorlatilag bármilyen területére az életünknek, ami hogyha egy valamit lehetne megváltoztatni, akkor ti azon a területen lépnétek, vagy azon a területen tartanátok a legfontosabbnak a lépést.
Én szívesen kezdem, akkor visszafelé el tudjuk indítani a kört. Ugye említettem az adaptációt, amivel hát szintén nem nagyon kell ebbe a körbe mondani, hogy a mitigáció.
So understanding why we are lagging behind within the individual sectors. So the agriculture is not moving. Slowly, and also the triggers are developing very slowly in the individual sectors, and at the end it results in economic consequences. So this is not only nature protection problem, but also a national economy problem, and every tool which helps us push the system into this direction, and legal instruments play a crucial role in this. So every tool of this kind is of utmost importance. One more thing, which is true for adaptation. So the decision, I was amazed by the saying in the Constitutional Court decision that you can also be lagging behind, that in such a way that effectively I don't make a regress from the regulation, but I do nothing and problems are passing by. And this is what happens in every sector. But in the forestry, first of all, maybe the water management started to move a bit in Hungary. So I have cited everything topsy-turvy, what I wanted. But these sectors should act in their own interest to develop climate resilience. And we need very strong help from outside to make these solutions happen. So once got it started, I like to follow. The major problem is, the biggest problem I think is, over the last 10 years, the lack of specialized politics logics in Hungary. Maybe for our foreign guests, this is a new information, but in Hungary there is no ministry for environment protection. So 5 different fields are assigned to 5 different ministries. On the level of the government, there is no independent representation for this sector, which would be a key to our future. And the lack of specialized politics and is also visible in the whole system of the authorities. In the green authority system, their independence was a lot impaired over the last 10 years with diminishing capacities. And in order to make well-founded and wise decisions, we need an independent ministry for environment, and we need independent, strong, well-equipped green authorities with proper capacities. And also, the lack of specialized politics is evident in the fact that in case of major investment projects, there are no environmental impact studies. This process started 20 years ago, and the governments always say that special investment projects are or VIP projects, and no societal survey and no impact studies precede such investments, and this is a huge problem. We green organizations and organizations in environmental law over the last 10 years just react before courts. And independent courts on their different levels, if there would be no wise and firm decisions after many years of litigation, if there would be no such decisions, then we would not be able to even to react. These are important fights, but no substitute for specialized policies from the government. So we should act on the level of specialized politics to make decisions that are wise and that can be implemented, and that would create no societal resistance we face in many cases. For a second, I would intervene and address our foreign guests. So in the Hungarian legal regulation, there is a priority project in terms of the national economy. This means that there are investment projects which are of paramount importance for the government, and legal investment regulations and rules do not really apply in such cases. And the problem is in the Hungarian legal system that any investment project can be qualified as a privatized project. And from this moment, in many cases, the main rule of the thumb is that these licenses even need not be requested and obtained and applied. Yet this should be the rule of the thumb in Hungary to be used. Two thoughts. The first is the basic arrangement of Hungarian society. Hungarian society is moved by money, and climate change and fight against climate change is something where many see a business opportunity. This is a huge problem, and coupled to this is the issue of awareness. On one hand, this is a milestone decision of the Constitutional Court, which I'm very happy about. But we can see that the securities, the collaterals, so the fuse is not molten in the public opinion. And I could see that we can see these headlines in the newspapers of the opposition of the government. But in other cases, this was not top ranked in other newspapers. And in the media of the government, this did not make any news. So it would be a huge task that for the different players of society, next, for example, in addition to the Constitutional Court, are become aware of the importance of this problem, and they try to raise attention to this important problem, to make everybody involved, as stakeholders, not only the state. And in order to make the actors see the importance of this, we are still far away from that. So the logic would dictate that I tell you something completely new, but I cannot invent anything new. Katalin and János cited very good things. I would highlight the forest and the water, but I would link it to our own work. So through our cases, we represent in front of the court what are the climate-relevant questions which are in the focus. In case of the forest, deforestation, unjustified deforestation, which in many cases is carried out without duly considering the aspects of fauna and flora. I see no willingness of the government, for example, in case of the water use. For example, we subsequently legitimate wells which are drilled without any license. So we have a bill, a motion in front of the Constitutional Court also about this. So if the Constitutional Court is that much sitting on this ecological train, then we do have hopes. We don't have a ministry for environment protection, and experts on the government side who are well versed in climate issues. Their non-existence is a problem. So in the course of the evolution of the environmental impact studies, it really does not emerge that in case of the environment impact study, just if you have an impact study of 300 pages, just half of a page is dedicated to climate change measures. And even this half a page says that climate change is not relevant. So the government has built a future on electric vehicles. And maybe it is only the government which says that this is a completely dead-end street. And maybe the lack of the force of the community, when a community would decide that, for example, forced industrial development is not desired, then in the most, so in the rarest cases, does the government take care of such reactions and such feedbacks? So these lines are good because at the end we have to be brief. Before I said that the loss of the habitats should be discussed. We should restore habitats. Biodiversity and climate crisis are the same thing. Different segments and different problems and solutions. We have an unlimited number of cross sections which can address both problems with categories based on the conservation of nature. So nature-based solutions should be endeavored when a kind of, in the course of the intervention to restore nature, we try to mitigate something or to attain something. And we have blunders which should be eliminated. I play basketball, so also in basketball we try to raise the attention, for example, to the importance of agriculture. In agriculture, we should address agriculture because agriculture is using a high quantity of land, and we could highlight that bird species are disappearing to an extreme extent, not only in Hungary but also in Europe. And lately, we could also show that which are the species which, in the long run are migrant birds, and use also other fields, other geographic areas impacted by the climate change and water habitats because of the territories, the worsening of territories temporarily covered by water is a problem. In many cases, for example, water management response can also restore the habitats. And we also have scrutinized where we have such territories, and we have come to an interesting conclusion. In Hungary, we have many areas where it makes no sense to have an agricultural farming, and these territories could be used very well to be used for the restoration of habitats. So we could use those territories to restore habitats and to promote climate adaptation, and maybe also promote the upkeep of farming in the long run. So this is a package where many stakeholders should be involved, and which is also highly promising. And I think we should really deal with that. And I don't address other details, but maybe agricultural territories are the most important part of it. of the story in Hungary. It is an exciting story. Is the issue of lawn or grass fields. The long run upkeep of grass covered areas can also be very important, also for the sake of biodiversity and water management. So because of that, we think that to preserve grassland and to restore them over large areas would be of paramount importance. Thank you. I have an easy job. We have heard many good ideas and proposals. Very briefly, I'm an economist, and our organization is 36 years old. Okay, check that. So sorry if I seem to skip the second question, but at the end I will be very specific. So what would be needed in the climate protection in Hungary? One of the problems in Hungary is that we want to resolve problems in the climate field, in the field of climate. We want to resolve problems in biodiversity, and we should resolve them in such a way that we give a positive response to all of them at once, without just focusing on individual sectors. And every society and every government has the main purpose of economic development and economic growth. And also these green steps would be serving that. We are very happy about renewable energies, but also renewable energies are also aiming at economic growth. So we are using existing structures to use renewable energies. So the third corner point is to change human culture in relation to nature. If we don't change our approach to nature, then all other relevant climate or biodiversity actions is going to fail. So I would here come back to the Climate Act proposal we made 15 years ago. So we called it Climate Action Bill or Climate Bill. I don't want to do a harm to anybody. We didn't want to include emission reduction numbers into this bill, but we have to include climate reduction numbers into every bill. But if we write numbers, then we just create transboundary loads for different nations. This would be a revolutionary thing. Talking about resource cap. So we have first made a proposal in the Climate Act bill that a fossil resources utilization cap should be established or determined by the Hungarian government in order to avoid transboundary load transfers. And we can see that such proposals are also the cornerstones of a different way of economic thinking and also a different approach to economic growth. And our climate protection bill would not have been important just because of the results. It would have changed also the mindset. And more than 560 organizations joined in the adoption of that Climate Act. And we also tried to transfer this type of mindset in the climate bill. So agreeing with everything what was told, we are so far that these cornerstones are no longer considered in case of such environmental regulations. If we would do the opposite, then we could change the situation for the better. Thank you. I would like to share two personal thoughts. The first is, recently, Henry Kissinger, State Secretary of the United States, said a few decades ago that if I want to talk to Europe, then whose number should I dial? In Hungary, in the climate regulation, we have a similar situation. As János mentioned, there is no one stop shop which could, there is no ministry that would address such issues. In the morning, I have told that climate is not traditionally meant resource, but it is linked to everything. This means that if we want to regulate something about climate, then it is interrelated to everything. So if it affects 5 different ministries, it means that 5 different ministries, 5 different departments should be reconciled, and different rounds have to be made. And there's no sole organization, no sole ministry that would tackle or at least coordinate these issues. This is one of the ideas and thoughts which may, is maybe a better overview for foreign guests as well. When I started to work at the Constitutional Court, my very first case was Natura 2000 case when the Constitutional Court found that there was an omission. It was made 8 years ago, and the legislator has not filled the gap so far. So also in cases where there is a legal obligation or an obligation by the fundamental law to remedy the problem, in due to many cases, this does not really happen. I would like to start the next round.
If I closed the previous circle with the bon mot, I would like to start a new one. Those who know me know this about me, that I'm a great fan of the Monty Python group. And there is a saying that what the Romans gave to us. And now, based on this, I would like to ask a question. What do you think? How do you evaluate in your own professional field what this decision added to your activities or to your everyday efforts? First of all, many things like responsibility that determines our activities and the societal parties and partners in the country. This principle, this special responsibility principle, should be applied. The NGOs have not started this responsibility today. They have been carrying this on their shoulders for decades. And so that decision should not only stay in the field of law, but it is applicable to the Hungarian Scientific Academy or the national parks or other NGOs. And the decision includes all the professional recommendations of all these organizations, and it gave us tools that we can use. There are important deadlines and important tasks, which is not for us, but for the government, so to say. But we would like to help this effort, and we would like to help the decision makers to comply with this deadline. And we would like to support the way leading to a decision so that we would have consultations before making the decision. And I don't want to pointing fingers at our proposal for a climate act, but that was a very good cooperation at that time. and it was the Society of Hungarian Conservationists and the National Council for Sustainable Development, and it is actually a council working in association with the parliament, which is a very innovative entity and organization, including all the parliamentary parties and other lobby groups. So perhaps this Sustainability Council could find some tasks for themselves in helping a new climate act to be put together. Thank you. I try to be very quickly summarize this, what has been said before, or this game changer decision. So what's important for us, I think a decision worth as much as it can be enforced, or to the extent it can be enforced. However, we made lots of references to, or the presenters made references to previous decisions, or the no withdrawal principle, or the. For me, the most exciting is that there's an ambition that is defined here, and the decision says that the act was not ambitious enough, and it is not just a step back, and the step back itself is not a problem, not the only problem, but the problem is that if an act does not rely on knowledge available at the given time. So when we have been, or I have been involved in nature conservation, there has always been the problem that those in the decision-making position are not ambitious in the topic, in the given topic. And so if we are talking about Natura 2000 areas, the message of the decision-making people were thinking that, we should not be the ones who select the most Natura 2000 areas. We should look for others, what they do, or they were thinking that, okay, let's be very comfortable with selecting the goals so that we are not the most hardworking guys. So it's very important to make a decision that you need to be ambitious because the conditions require you, or the circumstances, but also for the reason that because what the fundamentals that we agreed on require us to be ambitious and conscientious. And we also have to take into account new information, and we should set our ambitions based on such new information. That was my first reading of this decision, and for me, this is the most important message. Thank you. What I like most about this decision is the first one is a very simple. By the 30th of June 2025, Article 3 will cease to exist, and the legislator has a clear task ahead of them. The second item is that in a stream you have big stones, stepping stones, and these stepping stones symbolize important
milyen megfogalmazást használtál, de inkább azt mondom, hogy már az is a visszalépés.
So that no regression is also defined in the decision, because we cannot really have the situation that a law is not changed, however life passes by it. So within the scope of task of the representative of future generation has an important role, and I would I could even find a sentence in the decision that may improve the quality of the regulatory decisions and requirements. And the third interpretation, it looks like an encyclopedia, because if you look at the text, how no regression worked or applied by the Constitutional Court. And if you are very much interested in all this, you can read the whole decision, the text of the whole decision, but you can focus on or highlight on certain paragraphs. You can read lots of paragraphs on the conservationist background and history. Sorry, I would just like to intervene with one sentence, that if when you are reading a book, preparing for a university exam, you think that there are lots of redundant paragraphs. However, at the end, you realize that everything is important. The next speaker says that every law worth as much it is complied with. And unfortunately, it is stated in the decision that negligence has been committed on several occasions. And this decision is so important, and I try to imagine its future, but I can't see it at the moment. And I would just like to use a similar or a comparison. One of the representatives of the Climate Association said in northwest Hungary, so he usually mentions it, that we have a glass into which water is dripping, and then it gets filled up eventually, and then it spills or overflows. So we get to the borderline of something, and then eventually we need to act. In all the contribution of the water drops are needed to fill a glass, and I think this glass has been filled now, and perhaps this helps us to the stage where we have to act, and we will be able to accomplish changes that will take us to the good direction. Thank you for the opportunity again. First of all, what I liked about the decision is the novelty of the arguments used, and the inclusivity and the complexity. As far as novelty is concerned, it resolved legal, logical issues for which I was happy to read it, and for which reason I will be happy to make references to this, to the decision. For example, it introduces or reintroduces certain definitions or terms. We are trustees, and we are not only owners of the resources, but we actually borrowed it from our successors or the future generations. So it says that current generations' needs should be satisfied, that in the meantime we do not endanger the needs of the future generations. And we have another constitutional obligation, that we have to protect our assets and resources for their own sake, according to the Constitution. And the Constitution, or the fundamental law, protects our natural resources, but whether climate is a natural resource, and it was mentioned at the beginning of this conference that if we destroy or damage our climate system, if we endanger our future, then we will destroy our natural resources. And I think it's a very important credit to this wording of the decision. And as far as inclusivity, I have not counted how many organizations were involved by the Constitutional Court to make this decision. It was more than 50, and I think it was very important, and that is how the new climate law should be put together. 15 years ago, in Iceland, they made a new constitution. It was not made from an iPod, like in Hungary's case, but by involving 20 or 15 or 20% of the population. I think a climate law determines our present day and our future. And population should be involved. Very strict social debates must be initiated, which will later on help with the social legitimacy of a law like that. Because it's important to put together a highly professional material and from which they take some ideas. However, it would be a normal practice to involve all this. And I'm very happy that I could experience and see this normal or wise thinking in Hungary eventually. And I think the government should have this inclusivity in mind when putting together and developing the new climate law, and they should not see enemies but partners. And I think we will make references to this decision, and we'll be very naughty to use this, or not naughty, but very smart to use this, because it consists and includes lots of very good statements. And I will tell you the reason why we will use it very often. Because we have experienced this, like other nations in Europe, that political systems that are highly conservative and populist do not really like or do not really support environmental progression. And in a system like that, it's very difficult to draw red lines, which should be protected by all means, and the actions that should be taken by all means. And when it comes to draw red lines, we tend to fight very hard. And however, it's very difficult to find good partners in this mud wrestling. And the prestigious organizations are kind of amortized in this fight or mud wrestling, but a strong speaker or a strong voice in this fight was the Constitutional Court. And so when we protested against certain laws, we were highly criticized by the forestation companies. However, when the Constitutional Court did that, then they not protested. So we got a very good device, a strong device from the Constitutional Court. We are approaching the end of this, the first day of this conference. And as far as the topic of this panel discussion is concerned, I could say that many things were needed for the successful adoption of the decision. We needed the professional feedback, comments that might support the work of the Constitutional Court, and at least 8 Constitutional Court justices were needed to support this decision. And last but not least, we needed Constitutional Court justices who took on the task of supporting this decision, and I think I should give now the possibility to Marcel Szabó to say the closing words of today's conference.
This is extremely touching, but I didn't deserve it. Those who are sitting here at the table are the living consciences of nature protection in Hungary. When I worked before as a Green Ombudsman, we worked together with them, with the organizations, and they showed the way and the standards, have set the standards in terms of environment protection, which should be represented by the Ombudsman. And I'm sure that Professor Bandi can confirm that. We are extremely grateful for the input you have given to this decision. And decision has a legal and an extra-legal plane, which we wanted to represent. And the legal dimension is something where we wanted to use all creative legal solutions published in modern international law to interpret them in the Hungarian order of constitution. But there was a very important opportunity dictated by law, allowed by the Article B, by the fundamental law, that the legal possibility to protect the nature per se. We could talk about what has to be done. And I think that several countries and great specialists from these countries are represented here. And it is interesting to compare the different climate protection-related decisions. And climate mitigation is the major path on international level in court judgments. And so the top priority is carbon dioxide reduction. Mitigation has also another direction to enable mitigating sectors or mitigating factors. So the consideration of measures that can mitigate consequences of climate change, and this is called adaptation resilience. And we here at this international conference, at this panel, so the free, if I would add free red exclamation marks to the fact that we have considered, we have talked about birds, about biological diversity, about nature conservation, and about the landscape and the land, the destruction of which is at stake of this climate change. And that's where we reach a different dimension of this Constitutional Court order decision. And this is why we have tried to use the documents recognized by the state adopted, and to consider the strategies adopted by the Parliament, and asking the National Academy of Sciences to help as partner, and to ask for the opinion of all natural parks to collect the impacts of climate change, to give a picture to the whole country. And our baseline concept was that almost every week in the press, you see some alerting story about how our world is going to be destroyed. Okay, most people just scroll over it and see the next page to the next news. And in this regard, the fact that boring lawyers, the Constitutional Court are working, and the public opinion don't expect them to be concerned for climate, for nature. They say, okay, oh my gosh, we have that, and we have we thought and we expected that this would have a major impact on society. This has not happened yet. So we really put a lot of trust into your partnership to create this kind of a buffer to convey this important information to the press. And we want to also talk about the pathway from the origin of the news to the citizen. And the Constitutional Court cannot progress with that. Why? Because even if we pronounce it openly, we cannot make it so that public. So the reader is diverted in the jungle of information, and we don't know whether the reader will arrive at the black stalks affected by the court decision. So taking into consideration of everything what we got from you, a shocking picture has emerged in our minds, and we wanted to present that. We wanted to show that we have different tree species in our forests, and different papers, qualified papers, say pines are going to be displayed in the next decade. The other one, the beech is going to be destroyed because of lack of surviving capabilities. And the third says about the oaks, the same. And if the three things don't emerge in the same document, if I take it all, then I would say this is game over. And the Kiskunkaság Nature Conservation Area also says that we are developing in the time of terrain without forests. For example, the Lake Balaton could also lose a lot of water and develop a lot of algae. And the karst region of Aktelek is also jeopardized. And we should unveil that. And we try to say that also on the level of the Constitutional Court. So the nation and the community of citizens, they bond to this landscape is also an important element of our belonging together. And what we think is our homeland, Valencia Lake, the forest, Lake Balaton, or flora and fauna, nothing is left. This is so, because it will be going to change so radically that we will not recognize our country anymore. So this is a constitutional level question or issue which per se, if we have a red line mentioned by Katalin, which has to be drawn. If this is not a red line, then nothing else is. So this red line we should set together, and I would be extremely happy if this, if we could make a drumming-like event about that, and if the decision of the Constitutional Court covers also inland waters, for example. So the attitude that floods should be diverted quickly, this should be changed. That valuable forests should be kept or retained. So we have collected a lot of proposals and we have promoted them to society. And at last, I would like to say, I talked to the German Constitutional Court judge, and I asked her what was the most important impact or effect of this Constitutional Court order. She said the 6 moral effects assigned to the legal regulations. So unveiling the facts to the society. This was the most important thing. So we rely on you as partners, as the living conscience of Hungary in terms of nature conservation. Thank you very much, and highly appreciate your contribution to the conference today. The bad news is today we are going to come to an end, and the good news is we continue tomorrow. Thank you.